All right, good morning, everyone. I'm going to call the Rehab and Social Services sub on cannabis to order. Clerk, can you call the roll?
Senator McDougall. Here. Senator Reeves. Here. Senator Surville. Here. Senator Spruill. Here. Senator Boysko. Here. Senator Kiggins. Here. Senator McPike.
Here.
We have a quorum, Mr. Chair.
Thank you very much. First off, we're going to set the tone and an agenda for the day. We're going to have, just in order, we're going to have Senator Hanger take up Senate Bill 591. Then we're going to do Senate Bills 313 as well as 621. I know Senator Donovan has some commitments here shortly, so we'll try to get those up in a moment. And then take up Senator Evans 391. And so with that, we will go through as an overview, sort of larger sections, take up as a concept, and then the subcommittee will consider the policy options on the table for us to move forward with. We will go through as much as possible for both in-person testimony and online. Due to the number of folks in attendance as well as those online, we will be limiting those. And so I'd encourage those who have specific comments on bills to be very specific about what you want the subcommittee to know about. If there's an objection or a specific change or concern, please highlight that. And again, if you're coming up in broad support or broad opposition, that is fine as well to note that. But we do try to understand the specifics of what you might be interested in improving, changing, or deleting, and we'll take it from there. So with that, Senator Hanger and the committee, please turn your attention to Senate Bill 591.
Thank you. Members of the committee, Senate Bill 591 has started out as a simple bill, which basically the issue we're looking at here is that there are marketing techniques where there are gummies, as they're depicted, that are made, it appears, to appeal to children. They are sugar-coated in all kinds of shapes. I think it's inappropriate for them to be marketed that way. In structuring this bill, and that's all the bill initially did, and we do have a substitute that I would need some explaining before you all move to adopt it because it broadens the bill significantly. One of the things that I was involved with the landing team for ag and forestry, and one of the things that I'm very supportive of is promoting the growth of hemp as an agricultural commodity. There are a lot of good uses for that. What has happened is that there are products being developed where there's an extract taken from hemp, and then you have these synthetic derivatives, and you come up with little gummies or other products that are very dangerous. We've already had many instances in the state where children have gotten hold of them and have gotten very sick. I've had a lot of instances where, children, I'm not aware of a specific instance where they have died. You may be, because I know it's a terrible thing. But at any rate, the substitute, which should be online now, I will have to have David explain because he had to expand the bill significantly to embrace this particular feature.
Mr. May, can you walk us through as it's loading on the system?
Y'all got it? I don't have it yet. Let's see here.
Mr. Chair, okay, so the substitute retains what the bill originally did. It also makes some modifications to the definitions of marijuana and tetrahydrocannabinol throughout the code to basically provide that any of the substances, whether it be botanical or non-botanical product that has over a 0.3 percentage of THC is going to be considered marijuana, and that's regardless of the cannabinoids that are included. So what we did was we struck the references, for example, to Delta 9 throughout the code so that the definition of marijuana would cover Delta 8 as well, for example, 6, 7, 8, 9, 10, and anything that comes out in the future. To get that regulated underneath the market, it's going to be treated as marijuana, so you would have to have a license under Title 4.1 to make it and sell it. So you wouldn't be able to, basically sell Delta 8 at convenience stores any longer.
Questions for council? So I have a question for council. The changes that are made, are they picked up in Senate Bill 391 or other sections or other vehicles?
Mr. Chair, this is a standalone bill and I don't think that any of these provisions are included in the other vehicles.
Okay. Also, I guess as a follow-up, I know some of the bills also deal with sort of larger cannabidiol extracts in definition to try to deal with the catch-all. How does this position against those? Can you walk us through that?
Mr. Chair, so nothing conflicts. It can be laid basically right over top of the big bill that we have. We've done a lot of cleanup as well, but this is specifically surrounding the Delta 8 cannabinoids, which we have not addressed in, like, for instance, Senate Bill 391 as of now.
Mr. Chair,
Senator Boyska.
could I just ask a few clarifying questions here? Great, thank you.
Proceed.
And I guess this is probably more for David than for Senator Hanger, but Senator Hanger, if you know the answers, please chime in. Industrial hemp, I'm trying to understand the difference between that and marijuana. I'm not an expert in any of this. Can you help me understand why we're changing the definition here and what the purpose of it is?
Senator Boyska, so yeah, basically what you can sell as hemp or CBD, whatever, the typical things that we've been allowing the sale of for the past few years. For those products, you have a THC level below 0.3. So, for lack of a better term, it's not really things that can get you high. So that the whole point of these amendments would be to say that regardless of what cannabinoids are in your substance, whether it be Delta 9 or Delta 8, if it's got a lot of THC in it, then it's going to be considered marijuana. So if it has, psychoactive effects on the body, we want it to be regulated under the Title 4.1.
Mr. Chair,
Senator Boyska.
my understanding was that hemp products and cannabinoids, I hope I'm saying it right, did not have THC in them. Are we saying now that we're going to move and allow hemp products to expand their scope of what they're growing?
Mr. Chair, Senator Boyce, no, it's really a limitation. So right now, because of the references to Delta 9, there's some discrepancy about whether the hemp products can have a concentrated level of Delta 8. So really we're just limiting that to say regardless of what the cannabinoids are that are getting you to above a 0.3% of THC, it's going to be marijuana.
Okay.
Mr. Chairman.
Senator Servo.
I guess it's probably for David too. I carried a bill, I think it was 2 years ago, which put all this Delta 9 stuff in the code at the request of DFS because they were having problems differentiating psychoactive marijuana from hemp, and they needed to develop a new test to be able to properly differentiate it for criminal prosecutions, and that's why we went with the Delta 9 standard. So first of all, I hope DFS is here, number one. But number two, I'm sitting here looking at some of the criminal statutes, and on lines 380 and below, 380 through 392, you're striking out the marijuana field tests for violations of 4.11105, which I think is the new statute for possession of marijuana on school property or under the age of 21. And I see you've expanded subsection A to include marijuana defined in 4.1600. Can you explain that series of amendments to me?
Mr. Chair, Senator Sturville. Yeah, so in looking, for example, at like 18.2-251.1, the language about tetrahydrocannabinol is stricken because of the modifications that we made to the definition. And the language about the field test was, I think, was a request from the agency because they claimed that there was not a field test that existed, I guess, to be able to do this. So this is not, we don't necessarily need the amendments to 19.2-188.1. That was more of an accommodation, but it's not necessarily to the substantive piece of the bill.
Further question, Mr. Chairman.
Senator Sturville.
It's not a field test to do what?
Yeah, evidently it's the field test for determining whether something is marijuana. I'm not intimately familiar with this. If they're here, it'd be great if they
Mr.
could come
Chair.
up and speak.
Senator Reeves.
So that, in law enforcement, we carry these little packets that you can put a sample in and determine what it is before you make an arrest or anything else to solidify what we think the drug is. So that's what they're talking about.
Mr. Chairman?
Senator Sturville.
I know that, and I'm just curious why we're deleting law enforcement's ability to do a field test for a violation of marijuana under the age of 21 or on school property or otherwise, or whether or not, I mean, that's what I'm trying to figure out.
Counsel.
Mr. Chair, Senator Sturville, if like I said, this is more a technical accommodation for them at their request. So if at the pleasure of the subcommittee, we can easily just put that back in, and it's not going to make a difference in the substitute.
Well, I don't want to do that yet, but it'd be nice if DFS, if they're here or listening, could send me an email explaining what their rationale for that was, because we've been getting told for 30 years there's field tests for this. So, and I've been seeing them used in court. So I'm not really clear why all of a sudden they think they don't have field tests. And my suspicion is they don't have field tests that maybe can differentiate between Delta 8 and 9. Maybe that's what it is. I don't know. I just need somebody to explain that to me.
Other questions?
Mr. Chairman, if I could add just briefly, back years ago, we had a problem with what was called bath salts. The people who were putting out this stuff, you'd try to prohibit it, and then they would change the name, change the formulary, and still keep on putting it out there. This is similar. We got Delta 9, now Delta 8, and the attempt was made to basically categorize it in terms of the contents there that would give you the high, because that was not intended from hemp, but they are juicing it up. And we had testimony in our mental health commission where they had a son who had mental health issues. He'd get a hold of this stuff, and he just was uncontrollable once he ingested these types of products.
Yes.
Senator Sproul.
Thank you, Mr. Chairman. I'm listening very carefully what everybody's saying. I'm sitting here saying, Sproul, what in the heck are these guys saying? And I have a Democrat lawyer to my right and a Republican lawyer to my left. And all I want to know is, can you get high off of hemp or marijuana? Can you get high off both of them?
Delta 8, you can.
I don't know what the hell Delta 8 means.
Mr. Chairman, I've heard testimony to the fact and read articles that the way they juice it up, it's synthetic, but they add something to it that, yes, it'll knock your socks off.
But could you see, if I were to walk out of this room right now, and someone who's not to ask me, when we walk out of this room and say, Sproul, so what is the difference between one and two? I wonder what the hell to tell y'all. And then I'm being truthful, and I'm going to vote on this stuff, so I'm trying to get someone to break it down to me to really, so I can understand what is hemp that I never smoked in my life. That's why I look good for being a 75-year-old man. So I never smoked in my life, but I want to trying to understand when you say hemp or marijuana. I just want to understand. So someone to ask me a question, Mr. Chairman, so I can say yes, hemp is this, marijuana is this, and you can smoke and what have you. And I don't know, and I want to be able to vote intelligent on something when someone is saying so. I know they won't ask a question. I don't mind looking stupid, but I want to be intelligent, a stupid person, to know what I'm talking about.
Senator Hanger, you apparently have a friend who's approached the podium.
I don't know how much of an expert I am, but I want to just
Short form,
say
please.
that the cannabis plant, when pollinated, what we're talking about is the key ingredient is the THC level. That's the thing that has psychotropic properties that can get someone high. There's hemp that is not, I don't know if the word is fertilized or pollinated or a male plant or a female plant, but certain plants that have not been cross-pollinated can be used for things like making rope and things. But what's happened is they do have a THC content, a low THC content. Some of them are used for like creams and things, and you see what they call CBD. But what Senator Hanger's getting at, and it's a recommendation of the Cannabis Oversight Committee, is that we should, people are finding their ways around it because they're deriving different chemical compounds from the cannabis plant that will still get you high, but they're not technically what was defined as marijuana. So he's trying to do a good thing and take these things that can make you high from the plant. They're not the same as what's labeled as marijuana typically, what the medical processors are producing, but they're not good for kids or for people to have unregulated.
Thank you so much. I understand that, Mr. Chairman.
Mr.
I'm going to
Chairman.
follow my two lawyers and how you.
Thank you.
Mr. Chairman.
Senator McDougal.
Mr. Chairman, I have to agree with Senator Spruill's Democratic lawyer about that one section involving the test. I mean, either looks to me that either DFS doesn't want to have to do the lab results at the end if somebody requests they be done, and that could be why they want it out. But as far as a policy decision, I think that we ought to hear them affirmatively say this is not scientifically reliable, or we don't have these types of tests in order for us to take that section out. But the question I have, and this is David, really this boils down to the tetracannabinoid definitions where we go through. Do we have anybody here that can tell us? So you got Delta 6A, or was in parentheses 10A, 7, 8, 9, Delta 10, and any other substance containing detectable in that amount. So do you think the way that you've written that definition, and I guess we've repeated it a couple times, picks up all the hypothetical possibilities? Because if it's Delta 10 right now, my guess is it could be a Delta 11 tomorrow.
Mr. Chair, Senator McDougal, yes, it's my understanding that it is written in a way to where it will pick up all of those variations, because it not only, in changing the definition of THC, marijuana is going to be anything with the THC above the 0.3%. So really the THC definition becomes very important after that. And the way we have it phrased, it basically is going to include all of the deltas that are listed. So the 6A, the 7, 8, 9, and 10. But the second part of it is really the catch-all piece, because it's regardless of the cannabinol, if there's a detectable amount, it's my understanding, or it's possible within the specific chemical designation, which was some language I think that was ruled over this summer by various people. I don't know that everyone has come together and said this is the end-all be-all language, but this language was worked on over the interim. It's not something I just came up with.
Mr. Chairman,
Senator McDougal.
the possible, I'd like to know how to interpret what does specific chemical designation mean? Who's designating? So that's one question. And then how do I come up with the sum after the application of necessary conversion factor? Is that a defined thing? Is it always the same? Or is the definition the percentage by weight of the tetracannabinoid? So why wouldn't we be a little clearer in articulating that?
Mr. May, if it's early enough to do some math this morning, do you want to help us go through this?
Mr. Chair, Senator McDougal, I think it would behoove us to bring up one of the experts in the field who can talk about the testing, whoever that is, from the lab. We had someone speak last night in House General Laws. I don't know if she's here.
There we go.
But Mr. Chairman, because no, Senator Servell is going to argue this at some point, and he's going to ask a judge what does specific chemical designation mean? Who's making that designation? And he's going to ask about that conversion factor.
Senator
Why do we
McDougal.
have to make it sound like that? Can it be
Come
cleaner?
on up.
Hi.
Good morning.
I'm Becky Hobden. I was not the person that spoke last night, but I run ECC Test Labs in Ashland, and we have been working with hemp and the medical marijuana processors for the past 2.5 years, and we do all the testing, probably the primary testing in the state. So I can certainly answer a lot of these questions.
Did you have a specific answer to Senator McDougal's question on?
Well, it's two things. It's the existence of all these things within the specific chemical designation. Does that mean the substance we're testing? What is, who's making the designation? The wording, that wording doesn't seem
So
straightforward
I'm
to
not
me.
as familiar with this bill as some of the other ones that are being discussed today, but what we test for, and I think is a cannabinoid potency, and so you can target THC or CBD or CBG. There's also acidic forms of these cannabinoids, THCA, CBDA, or CBGA, among many others like Delta 10, Delta 8, and if you put specific names, they're always coming up. There's THC acetate, there's THCO. So there's definitely people figuring out how to slightly modify these cannabinoids. So if it says Delta 8, that's what it means in the legislation versus a broader term. I don't know what that term would be, but just, if you're putting specific compounds, molecules in the legislation, people are figuring out how to alter those slightly so that it would fall out of it. So that's just one thing to keep in mind.
Mr. Chairman.
Thank you. Senator Servo.
Yeah, so like I said, I got I got deep into this wormhole about 2 years ago when I carried the bill to define marijuana as Delta 9. And the reason for that was that under the tests, under the code, the way it was defined at the time and the way DFS was conducting tests at the time, you couldn't differentiate between some kinds of hemp and marijuana. And so that DFS thought if they used a Delta 9 as the distinguishing test, a certain concentration of Delta 9, that would get them to home plate and keep hemp processors from manufacturing an illegal substance. And so that's at least how I remember it being explained to me when I carried the bill 2 years ago. Getting into this, I've been hearing about this Delta 8 stuff and how psychoactive it is, from other lawyers and clients or whatever for a while now, like the last 12 months or something. So I appreciate where this is going at. I mean, it sounds to me like you're trying to go after animal-shaped gummies, kid-attractive gummies, and these other psychoactive things. And I'm sure Senator McDougal knows, remembers, is aware, whatever, that when we deal with this problem, when it comes to other types of synthetic drugs, my recollection is, isn't there some kind of administrative authority that allows DCJS or somebody to promulgate a new list, so that we keep up with this stuff faster than we can be in session and pass stuff effective July 1? And so just, obviously this piece of the bill, I think, dives pretty deeply into the criminal justice space and areas we've had to deal with before. It just seems to me that there might be some useful analogs there rather than to keep amending this Christmas tree list every year when the labs come up with the new Delta whatever that we're going to have to add to the list. So it seems to me that's what we're chasing right now. I wish DFS was here to explain what their capabilities are and how we got here, because I think that would be helpful.
Well, counsel, correct me if I'm wrong, but the language includes sort of the derivatives language to address just that, as determined by the authority.
Mr. Chair, yeah, I think it gets as close as we've been able to get to the time being. I think that was the goal. And this was, the prior administration consulted agency to agency over the interim trying to really work on this. And this is ultimately what they came up with. So the various labs were consulted in this process, and like I said, I'm not sure that there was a final consensus on the language, but I think this is as close as they felt that they could get, and I'm not sure exactly how the second clause operates to cover the rest. The way that it reads basically says, it's kind of saying tetrahydrocannabinol is anything containing a detectable amount of tetrahydrocannabinol. So, I mean, I get the confusion, but the labs were consulted, and as far as the language about the specific chemical designation, it's my understanding that because the cannabinoids are altered through various processes, like, for instance, the products that have high concentrated levels of delta-8, they use a process called isomerization, because, like, for instance, like a bud from a hemp plant, it's not going to have enough delta-8 in it without being altered to really give you psychoactive effects. But if you put a lot of that together, you put it through this isomerization process, then you can get it to a high enough level of delta-8 to where it will have effects. So I think the language there is trying to address that piece. But again, I did not come up with that.
Mr. Chairman, I think
Senator
Senator Serval's overall point is probably wise, but I was really trying to focus in on what the words say here. So is David, if I'm reading that in line 175, so you have the existence of tetracannabinol salts, the existence of isomers, or are we saying tetracannabinol isomers? Then tetracannabinol salts of isomers is possible within the chemical designation. When I'm reading those three together, I don't know that I come up with what you just said. So as far as work, so you're trying to say that the salts of the isomers can be altered within a specific item, and so that's where you need the specific chemical designation. If you're reading those things together, does within the specific chemical designation go back to all three items or just the salts of the isomers?
Mr. Chair, Senator McDougall, it could be any of them. I think basically you look at the specific chemical designation, and if in that designation the existence of tetrahydrocannabinol salts, tetrahydrocannabinol isomers, or tetrahydrocannabinol salts of isomers is possible within that designation, then it would qualify as tetrahydrocannabinol underneath this definition.
And maybe I'm just
Senator McDougall.
overreading it. But
We're gonna limit this due to time.
Yeah.
So I want to happily appoint Senator Serval and Senator McDougall to the chemistry lab, sub of rehab, to hammer this out. But I do want to. Is it the pleasure of the subcommittee to remove the 4.1 1105 section until it's resolved?
So moved.
All right. There's a motion and a second. It's the, what, 4.1, what was it?
19.2-188.
So you're restoring the field testing?
Remove lines 372 through 392. Just take them out.
That's right.
And Mr. Chair, just to clarify on that piece, I
Three-
believe what was said was that they have not approved, because the language is all conditioned on a test that's been approved as accurate by them. That's my understanding, is that there is no test that they've approved, which is why. But yeah, that would be the appropriate amendment, striking lines 372 to 392.
They may want their sub.
380, correct, to 392.
Well, we actually would need to probably keep the reference to 4.1-600 and 378. So basically, we would just unstrike subsection B.
That's right. All right, this motion is second.
Mr. Chairman,
Senator Serval speaking to the motion.
if the issue is that they don't have a test that is capable of determining it, then it seems to me like the statute is written as fine because it says you can only use an approved test. So I don't want you to take the authority out of the code. So I think we need to do this. And
That's
then-
what we're removing.
I got
restoring.
it. I got it. So then I have a second issue when we're done with this motion really quick.
All right, all in favor Aye. All opposed? All right. Senator Servo.
Mr. Chairman, the last question I had was the enactment clause says that there's 3 sections that are not effective until retail marijuana is allowed, which I appreciate the intent. I just worry about public notice and how people are supposed to know that date has occurred. You know, typically when you have a moment like that that's not July 1 or a specified date, there's some other official moment that occurs when the world knows, then the law becomes effective. Like, for example, the Cannabis Control Authority issues a letter certifying that all these things have occurred, and therefore the law enforcement, the public, everybody else knows that now these statutes are effective. That's the way I've seen it handled the very rare occasions when we don't have a specific date something becomes effective or the default July 1 is in effect. And so I don't like the way the thing is worded, but Mr. May, maybe you could draft an amendment to make that clear. I think, like Senator Eben, I know, carried a bill about 4 years ago about driver's license suspensions for marijuana, and the statute was not effective until we received a letter from the U.S. Department of Transportation certifying that we were in compliance with federal law. And it seems to me there needs to be something like that.
So, Senator Servo, I'm going to suggest that we take up that question with the other transition bills, because it becomes relevant on how what's proposed in Senator Donovan's as well as Senator Eben's bills become effective. And so these two or three instruments will tie together with that language. So that's something we need to come back to after we discuss the policy implications of their bills,
Right.
if that makes sense.
Mr. Chairman, I would just ask Mr. May to be working on that. It's probably pretty easy to find something to steal from, like Senator Eben's prior bill from, I think it was 3 or 4 years ago.
So, Senator Hanger, you've consumed almost all of Senator Donovan's time.
Yeah,
and so
okay.
we're going to work to wrap this one up, if you could, and then I'll take some public testimony on this provision. If there are those that are opposed to this bill, I'd ask that you approach the podium. If that's okay, we'll take those. If there's opposition, please come forward. And if there's opposition
Mr. Chairman,
in the Zoom room,
question to you before this starts.
please raise your hand.
Question to you first.
Senator Sproul.
If this is going to continue and you can let the 2 lawyers work on it, then why are you wasting time hearing testimony when the 2 lawyers who's on the committee going to work on it? Then they're going to do all that talking for nothing. Let them work on it first, then let them ask questions.
Well, Senator Sproul, we need to take public testimony on these bills and make sure that folks are heard with their opinions in this subcommittee. We will not be able to take an extensive amount of public testimony during our full committee with Rehab and Social Services. Our intent is to work through most of the public's hearing today.
I thought these 2 was going to work on this project and bring them back to us before you go to the full committee.
Senator Sproul, they will be working on parts of the provision, but we want to hear overall comments on the bill that's before us. Thank you, Senator Sproul.
Thank you, Mr. Chairman. And I think, obviously, I support the general thrust of where we're going. I think you all seem to as well. There are some people here that I want to speak for it. Maybe somebody wants to speak against it.
I think he's saying.
I'm asking for those in opposition.
Opposition. Okay. Opposition. Okay.
Morning, Mr. Chairman, members of the committee. Scott Johnson. I represent Golden Piedmont Labs, which is a hemp processor down in South Boston. We are a cooperative where we work with the farmers to grow hemp, and we process hemp there. I want to draw your attention to a piece of this substitute, which we're catching up on line 554. This is a change to the definition of marijuana. And basically, you've indicated on this bill you want to tap the brakes. I'm asking you to stomp the brakes, because unfortunately the way this is worded, you pretty much are going to put all of the hemp processors out of business. And here's why. Federal law and state law says before that hemp comes out of the field, it's got to be tested 30 days out, and the THC level cannot exceed 0.3, okay? But between that test and when it's actually harvested and when it processes, that THC level may go up or it may go down. The other thing in Southside Virginia, hemp has a higher level of natural Delta 8 in it. Just like Southside was known for good tobacco, it's known for good hemp processing. And Delta 8 is used in hemp processing to provide and develop other chemicals, like Delta 8 can be converted to Delta 9. And that is a natural process as Golden Piedmont Lab manufactures and sells to many of the pharmaceutical processors who are in this room today. And so the way this is worded, I know it wasn't intended, but it is a tragedy. I would ask you to stomp the brakes. Let's slow this down and not have unintended consequences. I'm glad to work with Mr. May and Senator Hanger and whoever you want on the committee, and I won't trespass further on your time.
Thank you, Mr. Johnson.
Mr. Chairman.
Senator Servo.
Sorry. Mr. May, my recollection of the bill I carried 2 years ago was that we were conforming our definition of hemp and marijuana to federal law. I mean, if we now deconform.
Mr. May.
Mr. Chair, Senator Serval, I am not positive. I'm assuming that we are. The reference that Mr. Johnson was referring to is basically just saying that even if something is considered a hemp extract, if that THC level goes above the 0.3, then it's going to be considered marijuana. Now, I think we could probably work this out to a point to where I know they have a process where they lower it.
Isn't that the law today? Once you go over 03, I thought it's marijuana today. It's Delta 9. Delta 9 over 03.
That's correct. It's because of the references to Delta 9. So this is really just keeping it the same, but looking at the other cannabinoids that are included.
Mr. Chairman, my name is Dylan Bishop. I'm here on behalf of the Cannabis Business Association of Virginia. To Senator Sorovel's point, hemp is defined in the federal farm bill to include any cannabis plant or derivative thereof that contains not more than 0.3% Delta 9 THC on a dry weight basis. The Virginia Code and also VDAX regulations conform with this. So if we were to pass this legislation, it would be in conflict with federal code, state code, and state regulations. While the Cannabis Business Association of Virginia wholeheartedly support the initial premise of this 3-page bill, unfortunately, we must align our comments with the gentleman that spoke before me and ask you to stomp the brakes on this 39-page substitute. Moreover, these regulated hemp products would be brought under the regulatory authority of the Cannabis Control Authority in bills like Senator Evans' SB 391, which we do plan on supporting later. So with that, again, Cannabis Business Association of Virginia would ask you to not act on this bill favorably. Thank you.
Thank you. Next speaker, and please keep your comments to about 30 seconds, just to manage
Mr.
time.
Chairman,
Thank you.
members of the subcommittee, Zach Lemaster with Gentry Lock Consulting. We represent a broad coalition of Virginia-based farmers and hemp processors, and I will just associate my comments with the previous speakers. Thank you.
Next speaker.
Well, I'm a for.
Please step up so those also that are online can hear your testimony.
Thanks, Mr.
Please.
Chairman. I'm for Senator Hanger's bill, so I don't want to speak unless you're ready to recognize us yet.
Okay. Is there any others in opposition in the Zoom room?
Mr. Chairman, we do have 2 people in the Zoom room.
Okay. Alan Denekas, you're up first. Please unmute.
Mr. Chairman, you had a speaker in front of me.
Alan Denekas, would you please unmute and begin your testimony? Mr. Chairman, I think he walked away from his desk.
Next.
Mark
online.
McCoy, would you please unmute and begin your testimony? Mark McCoy, would you please unmute and begin your testimony? I believe he has walked away from his desk as well,
Okay.
Mr. Chairman.
Yes.
Sir, are you also in opposition?
Yes. My name is Reverend Dr. Lester Fry, and I am the senior pastor of the Healing and Living Waters Ministry here in Richmond, Virginia, and I'm also the chairperson for the Black Coalition of Change, and I am the first vice president of the Baptist Ministers Conference of Richmond and vicinity. I thank you, Mr. Chair and members of the committee, for allowing me a few moments. I was sent here today by my friends and my relatives and my co-workers and church members to get an idea as to what really is going on about submission and approval of the plan to incubate independent cannabis retail and to support and educate persons that wish to participate in the cannabis market by the medical and hemp processors. Once developed, will that information be made available to the public in advance
before the authority begins their discussions. As the authority begins its work about this plan, how will voters and the public be informed about developments as they happen in real time?
We're going to take up some bills that are probably going to deal with this in just a little bit to what you're speaking about. If that's okay, we'd love to hear those, because we have a couple different bills that are going to address the larger cannabis industry, which you're speaking to. Yes, sir.
Good morning. I'm Marty Jewell with the Cannabis Equity Coalition of Virginia and second vice president of the Richmond Crusade for Voters. We support the overall bill. We came down here last year and testified extensively. Thought we had a good bill. What we're seeing here being presented, number one, is presented in the high art of gobbledygook. And then it appears to be the first cousin of antitrust. Now, I'm not a lawyer. Perhaps most of you are, but it's kissing right up to the edge of it. And then the $1 million that the industry or the companies would have to pay.
Yeah, sir, we're going to take what you're speaking to up in the next bills. So this bill is a different section that we're dealing with. We have two bills that are going to deal with the transition, which I think you're speaking to in just a moment, and then the larger retail access bill subsequent to that. So we'd love to hear your testimony. If you can hang tight so we can deal with Senator Hanger's bill briefly, we're going to come back to this topic. And
I just want you to know that we're opposed to both of them.
Okay. Thank you so much, sir. All right, Senator Hanger.
Yes.
Would you like to go back to banana-shaped bill or some gummy, some basics, rather than take this up and deal with this and
Chairman,
the other vehicles that are going to be going through the body? I'm just going to ask a question to simplify our lives a little bit, and maybe yours as well.
I appreciate all the time you've taken. I hadn't intended that it would take so much time, but I believe in working with David here, we've come up with a good product that has maybe 3 tweaks that y'all need to make to it. I'd like to see your little group try to address that, and if you come up with the answers while you're trying to address the other bills, that'll be fine too. I really do think we need to address the new products that are coming on. I think Senator Survell, his question about we need some way to make these recommendations without another bill later on. I think it was suggested by Senator Eben that the Cannabis Authority might be able to be delegated that authority. But I think the substance of this, if you can tweak the language so that lawyers can't do in-runs, and I understand that's what the conversation is about, then I think it could go forward. If the recommendation comes to the full committee, I certainly will try to defend that, because I think it's important for us to address this.
Thank you, Senator Hanger. And I'll just provide a quick comment. I think you're absolutely right. I mean, we're going to deal with it. The question is within which vehicles to deal with it in the appropriate time, versus having multiple vehicles dealing with some pretty important topics. You presented the committee with a consumer safety initial 3-page bill. We now have a 39-page bill, of which we have not had an opportunity to vet. So on top of the several 100-page bill that's represented in 391 and 2 other vehicles. And so we have already 12,167 lines of legislation in one bill alone that's before the committee today. So my suggestion to the committee is to go back to your original form and undo your substitute, and then we'll take up the other policy questions posed on the safety within the other vehicles. I'm going to put that to the committee as a discussion point. And any comment or thoughts on that?
Mr. Chair.
Senator Boysko.
I would support that. I think the essence of what you're trying to do is make sure that any sort of a product does not appeal to children, and I appreciate that. I am having a hard time, understanding how we're going to be on top of, as these products morph and change, how we're going to do that in real time. And I appreciate that that's, I think, the intent of your substitute. Am I correct? But I will defer to the concept of simplifying it for today.
And Mr. Chairman, I'm fine with that so long as the issue is addressed adequately in the other vehicles. If my bill can be useful to addressing it in a broader sense, I would want to preserve some portions of it. But I'll leave that to the discretion of the committee.
Any other thoughts or comments from the subcommittee on how to handle the concepts that Senator Hanger is putting forward? Sir, do you want to come up and speak? We're going to wrap this up.
Mr. Chairman, my name is Tom Antorcio, and I'm with the Virginia Catholic Conference, and we strongly support this bill and the substitute. And the reason for that, sir, is because the bill that, as it exists now, formerly SB 1406, chapter, I think it's 550 now, pre-reenactment, let's say, the bill that's currently in play, with the exception of a 5 milligram limit on edibles, this current legislation that we have in play in Virginia leaves potency levels practically uncapped. And that is the real fundamental issue here, in addition to the Delta 8 issue that we were talking about. Some products can include up to 99% THC, and that includes edibles. So we've talked about edibles, we've talked about gummy bears. The problem is that the industry knows that the profit driver in the cannabis industry is in the edible space. And so we're looking at gummy bears, we're looking at ice cream, we're looking at candy like Cap and Crunch, under names like Cap and Crunch and Trix. So I think you're familiar with that general issue. Just to look at it, the problem is toddlers. Toddlers are being poisoned.
Mr. Chairman,
We're going to wrap this up. Senator Sproul, real quick before you speak. So we have a suggestion on this, which is we're going to recommend that this go to a judiciary crim sub to work out the different provisions that you're asking to remove within the criminal section, as well as how this ties together. So we're going to have that refer Senator Hanger, if it's okay with you, to that to try to also have this heard by Friday afternoon. So we can make sure that there's some follow-up. We get a little bit more time in between to deal with the technical questions that you pose. I think as a subcommittee, we're in general favor of it, but we want to figure out and make sure we get it right in the process, and also make sure that from the crim standpoint, that we also make sure the codes do align. And so with that,
Mr. Chairman, a question to you first.
Senator Sproul.
Mr. Chairman, I would appreciate you get to speak with equal time. You're not giving everybody equal time. You're cutting some short and some long. So I would appreciate when those who are going to speak, you give them all equal time, because you're not doing that.
Senator Sproul, I appreciate that. It is now almost 9 o'clock, and we have literally hundreds of pages of legislation that has to get out today. So we were going to try to respectfully have people speak, but I ask that we wrap things up fairly shortly. I think we get the gist of what you said today. We're going to move this discussion off and recommend that the sub recommended reporting the bill as the substitute as amended and be re-referred to judiciary to go to crim sub. Is there a motion and a second? Senator Servell, is there a motion and a second?
I move to recommend reporting the bill with amendments and re-referring it to the Judiciary Committee.
All in favor, say aye. Aye. All opposed?
No.
2 noes. All right. Motion carries.
Thank you.
Thank you, Senator Hanger.
Thank you.
Senator Donovan. Senate Bill 621.
Thank you, Mr. Chairman. And I apologize for having a conflict, but with the move of the committee, I have some women that are expecting to see me today. So I will be very concise. I might be able to come back at the end of your committee. It sounds like an ominous task you have before you. And so if that's necessary, or speak at the full committee. I want to speak to you about a very slim portion of the conversation we're having today. And I believe there's a substitute for Mr. May from your council. And I would ask you move the substitute first.
Senator Donovan, you're starting with a 2-page bill. It does not transform to a 40-page bill, does it?
No, sir.
All right. You're doing well.
I haven't seen the substitute, but no, sir, I think we took stuff out.
Council, you want to give us an update on the substitute, please?
Mr. Chair, so this is an altered version of the transitional sales bill. Really, I guess the most important differences are going to be comparing this to Senator Evans' transitional sales bill when it comes down to it. But essentially, under the terms of the substitute, pharmaceutical processors would be able to engage in transitional sales. This would be starting in due course, so that'd be July 1st of 2022. And it would be under the control of the Board of Pharmacy and the current Board of Pharmacy regulations altered in this bill slightly until the Cannabis Control Authority could basically take over those regulations and start to enforce at least this limited piece. So not necessarily issue licenses underneath Title 4.1, but just be able to control for the time being the pharmaceutical processors engaging in transitional sales prior to the opening of the market pursuant to the terms of this act.
Mr. Chairman.
Senator Donovan.
Thank you, and thank you so much for council explaining. Essentially, council explained the bill. The difference in the substitute that you see before you is to basically remove from this bill any subject of controversy or issues that may be in any of the subsequent bills you entertain or the legislation last year regarding where money goes or anything else. The single focus of this bill, Mr. Chairman, is to start adult regulated sales in Virginia by July 1 and how we might go about doing that with a specific sunset clause so that when the Cannabis Authority is ready to take over with all of the decisions that are made in that legislation, that they take over and this would sunset. Mr. Chairman, I speak to you in the committee today as a physician and as a mother and as an advocate for medical marijuana in Virginia for the past many years. I will tell you as a physician that we have many Virginians, and many of them are pregnant, who continue to use marijuana, and there are many obstacles to them getting medical marijuana, and quite frankly, they don't have the same responses they do to what we would have in adult regulated marijuana, but they are subject to uncontrolled, untested, and unregulated marijuana that they are purchasing illegally, because in Virginia right now, it is not legal to purchase, but it is legal to own. Mr. Chairman, we can solve that problem with this bill. The other really important concept here is as long as we don't have a legal means of regulation and sales, we have children that have greater access to marijuana than they would if this were a regulated industry in Virginia. Mr. Chairman and members of the committee, people are concerned that we're giving the pharmaceutical processors a leg up or an advantage here. I will point out that this bill does not change the 7% of the market that they would have when the Cannabis Authority is put into place, but it does give us the opportunity to have high quality, high regulated, high tested, reliable availability of adult regulated marijuana in Virginia as early as July 1. And for those and many other reasons, I would urge you to include this language in any bill that you have going forward as we process all the other information you see today. I will point out also that this does impose slightly on the Board of Pharmacy to develop the regulations between now and July 1. However, it is not an enormous imposition, and Mr. Chairman, we all know that the Board of Pharmacy is the subject matter expert that is a portion of the Cannabis Authority that would be helping them determine these regulations anyway. And so it would be a head start on those regulations that would ultimately be determined and adopted by probably very much the same people on the Cannabis Authority. And so, Mr. Chairman, I am probably going to leave very shortly, but I do have people that can speak to this bill, and I'm happy to entertain questions from the committee now, and am happy to be available either at full committee or maybe at the end of this committee if that suits you.
Okay, questions from the committee?
Mr.
There's
Chair.
Policy questions on the table in terms of opening up retail access July 1 through the existing medical providers, as well as other provisions. Senator Boysko.
So in the omnibus bill, the difference between what you're offering and what the omnibus bill is that your date is different? Is that
date is different and who promulgates the regs. And my date is definitive. I would point out that in some of the other bills you're going to see, we expect the Cannabis Authority to have promulgated regulations by, say, January 1, 2023, but that doesn't speak to sales and availability. And so I think this is a really good bridge that we can build. And again, this bill is sanitized for any of the controversial issues that we have to have conversations about. What this bill does singularly is move the date up. Virginia really needs to have this. I think this is a thoughtful way for us to move forward and make sure we get to the advantages of adult regulation, both for those that are consuming and those that should not be consuming.
Other questions from the committee?
Mr. Chair, I have a
Senator Kagan.
quick question. Will the medicinal facilities then continue to distribute the regular marijuana products after that comes on board in 23?
Mr. Chairman,
just medicinal.
Senator Kiggins, no, they were always included in retail sales of adult regulated marijuana, 7% of the licenses going forward. So they would move forward in the same alignment as was determined in the bill last year, is included in the bills.
Okay, and so how does that incentivize people to go through their healthcare provider to get the product if there's a medicinal section and then just a retail section? Wouldn't people just skip that step of going through a healthcare provider? And use the
Mr.
retail
Chairman, and Senator Kiggins, a couple of things are coming up. There are going to be process changes in medical marijuana. It is really an obstacle to patients to get registered with the Board of Pharmacy. So medical marijuana would be very different going forward. It will be different no matter what we do, because we are now making adult regulated marijuana available in Virginia. But there would still be value for patients to go through that process to get advice. But honestly, it has become a little bit of a problem. It is very expensive to get the recommendation to get medical marijuana. It is then also an obstacle for patients to register with the Board of Pharmacy. So I think the value of this bill, to put in context, I think we get to the same point you want. When this goes through our processors, you still have a pharmacist there. A pharmacist that can counsel and advise as they would if they were going through the medical marijuana process. Now they'll be able to do that for more people. And so, in a way, it's almost extending in many ways the value of the pharmacist's input for being medically informed. That's actually important for the pregnant women who are using marijuana. They are now purchasing on the street and they don't know what they're getting. And the manifestations and effects in an individual are very different depending upon what strain of marijuana they're getting. So I would say in many ways you're extending the umbrella of expertise to people even in the retail market.
Senator Boysko.
Thank you. So can you just refresh? This is going to sunset once the Cannabis Oversight Board really takes over. Does yours have any sort of an integration as far as like, the 3 tiers of manufacturing, selling, growing?
This bill would keep it as, and I'll have some experts weigh in on that, but this bill actually keeps the structure the same for the way the processors now function, and they are vertically integrated. It does unleash access to determining how much they need to grow to meet the market needs, but it does not. But it keeps it all in a very structured, regulated. And I don't know if you've toured any of the processors, but they're cleaner than a hospital.
Other questions?
Mr. Chairman.
Senator Servo.
I just want to make sure Mr. May conforms the enactment clause on this with this kind of things we were talking about before on the other one, because this one needs similar changes.
And Mr. Chairman and Senator Servo, to that point, I think the specific start date that we have here is very helpful for informing people in advance. If we're July 1, we're July 1. And that's an easy point of communication without waiting for regulations to be adopted.
Mr. Chairman.
Senator Servo.
Thank you. Yeah, I'm talking about the date it expires, though, because the your Section 8 enactment clause talks about it being the date retail sales begin or something like that, and that I'm not sure anybody's supposed to know that without somebody certifying that it's actually occurred. So just
I understand.
Yep. Other questions? So I do have a question, line 47. You have listed that the quantity of infused cannabis product is 500 milligrams of
Mr.
THC?
Chairman, I'm pulling up I did not have access to the substitute until it was just published, so I'm trying to pull it up as we speak. I'm going to let one of my subject matter experts discuss some of that information. I'm more of a conceptual advocate than perhaps precision on that. And unless there are any other questions directed towards me, Mr. Chairman, I will go.
Okay.
May I?
Thank you.
Thank you so much.
Mr. Chairman, Hunter Jamerson, representing Jushi. I'm happy to answer the subcommittee's questions.
So the question is line 47 of the substitute list, the threshold of 500 milligrams.
Yes, sir.
Can you explain?
The intention, Mr. Chairman, members of the subcommittee, the intention lines 45 through 47 are to establish the transaction limit for purchase of a retail cannabis product and limiting that transaction limit to effectively an equivalency of 1 ounce of material depending on the form of the product. So for example, subpart 1 is 1 ounce of botanical, the flower material. Subpart 2, 5 grams of cannabis concentrate. And subpart 3, the intention is for infused products, which would include some edible products, to have that 1 ounce maximum as well.
So would that not be 50 milligrams versus 500 milligrams? Don't we typically work in units of 5 and 50 or 10 and 100 versus 500 milligrams?
Mr. Chairman, I confess as I'm an attorney and it's very early, so I trust your math.
You have someone stepping up behind you.
That is the difference between 50 milligrams for an entire package versus 500 milligrams for up to the converting the total 1 ounce possession limit for how much you could purchase in a single transaction. So each product would still maintain the 550 limits that you have established elsewhere, but it's just converting from 1 ounce of botanical, which you can purchase in one transaction, to what that means in an infused edible product up to the possession limit. Does that make sense?
Okay. Thank you.
So package size versus individual product.
Okay, thank you.
Thank you.
We're going to take up Senator Ebbins' bill. Just so you know, these are both aligning sort of the same policy goal. We want to address these and allow Senator Ebbins to present his bill, how it addresses and approaches the transition somewhat differently, and then have the committee discussion on a vehicle to move the concept forward. We'll take public testimony as well once we hear Senator Ebbins' presentation. Senator Ebbins.
Okay. So Senator Donovan set the stage for why we need early sales, that there's an illicit market, product is legal, people should be able to buy it. And she maintains the pharmaceutical processors are the best way to do that. I agree, but I also have in my bill, as introduced, hemp processors, a limited application of hemp processors being able to conduct sales as well. They would take a little bit longer to get started because they've not produced met the same standards yet that the medical processors have. It would require that in my case that they submit to the board and comply with a plan describing how they will, in their health service area or other area determined by the board, both educate consumers about responsible consumption and incubate.
Senator Ebbins, let me interrupt you real quick. Do you have a substitute that we can get
I
before the committee?
apologize. There is a substitute. Yes.
Okay. So there's a substitute for the committee as well. There's a motion, second. All in favor of adopting the substitute, say aye. Aye. All opposed?
For the committee's edification, the difference with the substitute is it puts a limit of 80,000 square feet of canopy for how much the providers would be able to cultivate to keep them from getting to be too big as this market starts and dominating it in full. It requires them to submit to the CCA board, and that's a difference. It's under the Cannabis Control Authority rather than the Pharmaceutical Board of Pharmacy. they would have to submit to the board and comply with the diversity, equity, and inclusion plan and incubate five qualified social equity applicant retailers for a period of 6 months and educate those who wish to participate in the cannabis market. They both have $1 million fee. I should say, Senator Donovan referenced a date certain. The intent of my bill was to have a date certain of January 1st for sales to begin. And I thought that's how we wrote it, but that's the intent, so if needed, we could change that. It also puts in the local sales tax of 3% that we agreed to last year for retail sales. And that's so the main differences are Cannabis Control Authority, which is developing expertise and will eventually be the final regulator, would regulate. And mine is January 1st as recommended by the Cannabis Oversight Commission rather than July 1st. She would like to begin on July 1st, and we would like to move it from the Board of Pharmacy to the people who will ultimately regulate and have up to 6 months to do that. I don't know if there are questions.
Thank you, Senator Eben. I know you've been through a lot to help to summarize what the moving parts are, and I think you've introduced a couple different concepts from Senator Donovan, one of which is from the Cannabis Oversight Commission, sort of recommendations for at least hitting a January 1 of next year as your target, right?
Yes,
You've also introduced a canopy cap issue to sort of deal with how do you deal with market expansion and advantage issues while also sort of tackling some of the social equity, I think, questions that we've had last year that you've sort of rolled into this transition bill this year. Is
That's
that right?
correct. And we have about the medical people would get about 7% of the retail licenses, so the canopy cap is to keep them from, and they'll have an advantage starting early, but it's worth giving that advantage in order to meet the demand.
Senator Sproul.
Yes, Mr. Chairman, he said something about the change the date. Do we need to make a substitute to change the date that you were talking about from Senator Donovan and what's yours? Did you want to change that date?
I prefer to do January 1st because the Cannabis Control Authority, I think, can promulgate the regulations and have this happening. It's a difference of 6 months.
Okay, thank you.
Thank you.
Mr. Chairman.
Any other questions before we go to public testimony?
Mr. Chairman.
Senator Reeves.
I had to text Senator Eben about a change that some folks feel is very, very important, and that is to make sure that as they go through this process and they do cuttings and these sort of things, that some of that product, residual product that's left over from the cutting and stuff, just don't just get disposed of. So I was hoping we could get a line item, and I think Mr. May has that already. If David could go through the line item, I can't pull the substitute up to tell you where. I think it's line 5328, but I'm not sure that's the same one on the substitute.
Are you talking about the other bill, the larger bill, perhaps?
No. Mr. Chairman, disregard. It's on the larger bill. I'm sorry. Senator Eben.
No problem. Senator Boyce-Gill.
Thank you, Mr. Chair. So as I've been reading this, I'm feeling like we really should focus on cannabis as opposed to hemp. And I would ask that we consider striking the references to hemp in this bill.
Okay. So there are some specific lines that we would have to change, council, to change that. There's a motion and a second.
Mr. Chair, yes. It would be, it's going to be in various, if we took that out, it would be in various instances throughout the bill. Hemp processors are mentioned in almost every single section. I'd be happy to go line by line to let you know, but we could remove them without making any other substantive changes easily, just by striking the references.
Okay. There's a motion and a second, and this would somewhat conform to a little bit of Senator Donovan's concept, I believe, as well.
Right, simplifying it to those who are already producing this for human consumption.
Okay. There's a motion and a second. All in favor say aye. Aye. All opposed? All right, motion carries. And council, you'll work through for full on making those adjustments as necessary. Senator Boyce-Gill.
I have another suggestion here around the fee for vertical integration, I believe. Instead of 1 million, I would suggest that we increase that to $6 million.
Okay, that would be line 38, changing from 1 to 6. There's a motion and a second. Discussion.
Mr. Chairman.
I
Senator
think
Reeves.
it's line 40 of the substitute.
Mr. Chairman, I think that's line 38.
It's 38.
Oh, it's 38?
Yes,
But
sir.
I'd like to know why we're going from 1 to 6. Are we trying to price people out? I mean,
No, I hope we don't price people out. I've been struggling with what the magic number is. There's a lot of money to be made in this industry. I'm not suggesting necessarily that 6 is the magic number. Senator Boysko had told me yesterday she thought $1 million was too low. But they're going to be getting an incredible market advantage, and will be making millions upon millions of dollars. So it's not my amendment, but I don't know what the right number is. If 6 is the will of the committee, that's fine with me.
So Senator Boyce, can maybe clarify also, is that a one-time fee? Because I believe the difference also between this transition bill and the other 391 is, as written, they are paying $1 million each time for each the early access permit, and then applying again essentially for the vertical under the permanent code for a two-time fee is the way I read the codes.
Mr. Chair, my
So, is it one-time
suggestion
fee?
is the one-time
Okay.
fee would be $6 million. This is going to be a huge industry, and
Okay, that's helpful clarity. So there's a motion and a second. All in favor of the amendment by Senator Boysko, say aye. Aye. Any opposed? One opposition. Motion carries.
Two
I think.
oppositions, pardon me, sir. There were two oppositions to that.
Senator Kiggins? Okay, 2. Thank you.
Okay. So I think the differences between the two bills as they stand are fairly clear, just whether we're going to rely on the Virginia Cannabis Control Authority, which is developing expertise and will ultimately be the regulator to do this, or whether we want to rush through 6 months earlier by having the Board of Pharmacy, which it shouldn't matter. They didn't express an interest in it, but when the committee that you serve on, sir, the Cannabis Oversight Commission, felt like January 1st was enough time to have sales begin with the CCA setting those regs and transitioning.
Okay.
And just to confirm with council, the way the bill's written is the sales would begin on January 1st. Is that your interpretation?
That's correct. That's correct.
Thank you, Senator Ebb. So we're going to open up for a public testimony. If we can have those who are here in support, please come forward, as well as if you're in the Zoom room, start to indicate support, and we'll go through the cues. And again, for brevity's sake, if specific points, please address those, and we'll try to work through those with you. Thank you.
Mr. Chairman, members of the subcommittee, good morning again. Hunter Jamerson for Jushi. I wanted to first begin by answering further questions Senator Kiggins asked. Mr. Chairman, Senator Kiggins, you asked about the medical processors, and through Senator Donovan's bill, would the medical processors continue to service the medical market? What would be the incentive? We would. Neither of these bills would change the medical standards, the medical marketplace at all. The incentive, I think, for a medical patient is that under both of these bills, you could still access a 90-day supply as determined by your certifying practitioner and the dispensing pharmacist at the medical dispensary, which could exceed the legal possession limit of 1 ounce. Additionally, you would avoid the excise tax and sales tax that are imposed in these bills. So we think there's significant advantage to medical patients remaining even after transitional sales. I appreciate that question. Mr. Chairman, you serve, Senator McDougall serves as well, Senator Survell, on the Cannabis Control Authority's Legislative Oversight Commission. I'm respectful of the recommendation that was made for January 1 start date out of that commission, but I go back to echo, and Senator Donovan had to leave, but to advocate for her position. Why are we doing this, which is ultimately to solve a public safety, public health issue created by legal possession without legal sales? We have the opportunity to solve that problem on July 1st to provide Board of Pharmacy approved, vetted products through tested laboratories, third-party arm's-length laboratories. We can do that in July. We don't have to wait until January. I think the choice here is about the certainty of how soon can we protect the public. We can protect the public with certainty on July 1 through the provisions of Dr. Donovan's bill with the Board of Pharmacy's involvement initially and the July 1 start date. We risk uncertainty by relying solely on the CCA's regulatory promulgation schedule. This is an agency, as I understand it, that has 2 employees presently. I'm very hopeful it's built out quickly, but it's doubtful to me that on January 1st they'll be in a position to regulate the marketplace as the Board of Pharmacy could in the interim. And as soon as they're ready, if it's July 2nd, if it's January 1st, then it's transitioned under Dr. Donovan's proposal. Thank you, sir.
Thank you. Next speaker. Good morning.
Good morning, Mr. Chair, members of the committee. J.M. Padini on behalf of the National Organization for the Reform of Marijuana Laws. While we do support both bills in their general approach, we are strongly in favor with Senator Donovan's July 1 start date. It would be in the best interest of public and consumer safety to provide Virginians with access to cannabis products that are safe and conveniently accessible. Thank you.
Thank you very much. Next speaker.
Mr. Chairman.
Please approach the microphone.
Yeah,
Speaking in support.
Oh, sorry. I'm not supporting this bill. I'm against it.
Okay, we'll call opposition shortly.
Thank you.
Those in support.
Well, you're for moving it back to January.
No, they're moving this bill up.
You can express
Okay, go
your
ahead. Sorry,
preference.
go ahead.
Express your preference for the date.
Yeah, from what I'm understanding, and maybe I can be corrected, that the gentleman was talking about moving it back to January of '23. Am I correct?
Yeah, there are 2 policy options before the committee. One of which is looking at having our current medical providers of cannabis provide a start date of July 1, or one that would be January 1 of next year.
We support strongly moving it back to January 1 of '23.
Thank you very much. Those in the Zoom room that are in support.
Mr. Chairman, we do have 8 speakers on the Zoom. Anthony Jones, would you please unmute and begin your testimony?
Yes, thank you so much, Senators, and thank you for this opportunity. My name is Anthony Jones. I'm a small farmer here in Dinwiddie County, farm number 4752. I've been watching the proceedings as they've been going on, and I'm quite interested in the fact and in support of this bill, in particular the ability of the hemp farmers to move themselves to the front of the line. As an African-American farmer myself, I would like to also request that we already have in Virginia a USDA mandated hemp program that requires registration. That's important because as a potential social equity applicant, I would like to be able to access seeds legally. That's very important to me because I'm behind the 8 ball already. And so I would like to be able to acquire these appropriate types of genetics so that I can put these genetics into organic ground that I have prepared here in Dinwiddie County and give me the opportunity to catch up with regards to my expertise in growing this particular type of plant. My goal would be to provide services to those who cannot afford it and to veterans in the future when that particular opportunity comes in place. But as of right now, I am unable legally to purchase seeds, particular and genetics that are organic in their content. And so I would like to be able to use what already exists, the hemp the hemp registration process to register my farm, and so that I can go through a process and be able to acquire these seeds legally and be able to show record keeping for them.
Thank you,
Thank
Mr.
you so much for this time.
We have about a dozen more speakers, so I'm going to ask your comments to please hold to about 30 seconds, 45 seconds, and please continue. Next speaker.
Philip Thompson, would you please unmute and begin your testimony?
My name is Philip Thompson. I'm with the
cannabis equity consultants. This process is so contrived, it's ridiculous. You allow the medical cannabis people to select these groups without any equity considerations, and now you're just going to hand the market to them without having a real program for dealing with equity and inclusion. You've got this sharecropper amendment that Mr. in the bill where they're going to supposedly work with some minorities, but you have no real equity-based program, and it's very troubling that this process has moved forward. And people are coming to testify today saying, "Oh, there's a health crisis." Where's it at? You presented no evidence of any health crisis. You've shown nothing that shows that people are having problems with or falling out from marijuana that they're buying on the streets. This is a contrived process that's been set up by the medical cannabis people from the beginning, and all of you senators and representatives are falling for this trap, thinking that you have to do something where you really don't. You can slow this process down and develop a real program that allows the people who've been impacted by marijuana enforcement, and you know who we are, and put a program together that's really going to address these issues. What's in these bills is not a program that's going to help minorities to get into this business. Where's a person that's been arrested going to get the millions of dollars to get into this business?
Thank you, sir.
We hope that you delay this bill. Thank you.
Thank you. Next speaker.
Chelsea Wise, would you please unmute and begin your testimony?
Hi, thank you so much to the committee. My name is Chelsea Higgs. I'm with Marijuana Justice. I just want to say from the beginning, particularly about the roadside tests that were discussed before, I think it's important that we remove any language that provides the opportunity for law enforcement to use roadside just in case it comes up. Most of the conversation about those roadside marijuana tests are against civil rights across the nation. So I think it's important that we look into that. Number two, I really want to just say that the public health crisis that the Jushi people are presenting, the people that will gain the most in increasing the market time up, are the ones that are presenting our public health crisis, not health experts, not people that have so much to gain from accelerating these sales. Also, we want to just look at the cost and the collateral consequences that are truly life and death to people versus consumers that just want their weed when they want it. Like, these are the things that we decided to hold off on sales till 2024 because of the JLARC report said by doing that, we would then yield the most equity as well as the most beneficiaries. As the previous speaker said, there is no social equity included in this transitional market. Best practices show that social equity actually get the head start. So when we're talking about who's left behind, who's getting the head start, the people that will be the most impacted will be social equity operators, and the incubators that are in the bill. We can say right now that many people across the nation have called those sharecropper models and have not worked. And so the future are there. And also,
oh, I'm sorry. Sorry about the cutoff there. But we appreciate the testimony. Next speaker.
Aubrey Adams, would you please unmute and begin your testimony?
Hi, I'm opposed to this bill. Is this the appropriate time for me to make a comment?
Not at this time. We'll come to opposition in a moment. The next speaker.
Kalia Harris, would you please unmute and begin your testimony?
Good morning, Chair and Senators. My name is Kalia Harris, and I'm the Executive Director of the Virginia Student Power Network. We are a statewide organization that represents hundreds of college-age young people in Virginia, and I'm here to urge you to consider legalizing marijuana with a strong racial equity focus. So I echo the past two speakers before me and just add that Black and brown youth aged 18 to 25 are the most impacted by marijuana enforcement in Virginia. And I urge you not to legislate new crimes into this bill, including felonies that can take away opportunities from students to get financial aid, housing, and employment in the future. Thank you.
Thank you very much. Next speaker.
Roy Tucker, would you please unmute and begin your testimony? Roy Tucker, would you please unmute and begin your testimony? Jason Blanchetta, would you please unmute and begin your testimony?
I apologize, Mr. Chairman and committee. I wanted to speak in opposition. I signed up a little too quick.
Not a problem. We'll come back to you. Thank you.
Mark McCoy, would you please unmute and begin your testimony?
I'm also against the opposing, so I'll have to wait.
Kelvin Maners, would you please unmute and begin your testimony? Kelvin Maners, would you please unmute and begin your testimony? Shara Gibson, would you please unmute and begin your testimony?
Good morning, everyone, to the committee and everyone in attendance. My name is Shara Gibson. I'm the founder of Cannabis Ventures. I provide small business technical assistance to aspiring entrepreneurs looking to onboard into the cannabis industry. I'm in general support of this bill. However, with that $1 million fee that's supposed to go towards incubating small businesses, I would like the committee to consider using some of that funds to develop a broad capacity building program for minority and small businesses located in Virginia. There are lots of entrepreneurs who are participating unwillingly in the illicit market, and they want to legalize their businesses. And just having a fund for 5 businesses to be incubated will block out many other entrepreneurs who are interested in the cannabis industry. Thank you.
Thank you so much. All right, those in opposition?
Mr. Speaker,
in the room.
Thank you. Mr. Chairman, pardon me. Mr. Chairman, my name is Tom Atorcia with the Virginia Catholic Conference. We oppose moving up the date of commercialization in any form. The bill currently sets the date at January 1, 2024, as you know. The reason we oppose that is because no major medical association in the country supports commercialization, including the American Medical Association, the American Academy of Pediatrics, the Virginia Society of Medicine, and also the American Academy of Family Physicians and the American Academy of Medical Ethics. They all oppose commercialization of marijuana. And just finally, this strikes at our most vulnerable children right now, because especially among Black and brown communities, because they are suffering intensely from a mental health crisis that is unparalleled. And so this is only going to add to the weight on their shoulders, because we're going to have increased substance abuse, we're going to have increased overdoses, we're going to have high potency THC available like candy, and that's going to cause a lot of illness. So we would just ask you to please keep that in mind and look at a later date like January 1, 2024 at a minimum. Thank you.
Thank you very much. Next speaker.
Mr. Chair, Senators, not necessarily here in opposition, but just a few points of commentary. First of all, the increase of the fee from 1 to 6 million, I would recommend that there be perhaps some discussion or delegation for any additional fee to the regulator to determine that. That 6 million is higher than numbers that have been floated for medical inclusion in New York, which is one of the largest cannabis markets in the world. So while I agree there's much economic opportunity here, not just for the medical operators, but for all of Virginia, it might be worthwhile to spend some time thinking through and rationalizing what that fee would be and how to increase it if that's the will of this body.
Thank you. I'm sure we'll have plenty more discussion on that as the bill processes through the Senate and the House.
Got it.
Thank you. Next speaker.
Mr. Chairman, members of the committee, Greg Habib from Gentry-Lock here on behalf of a broad coalition of Virginia farmers and hemp processors. Just a couple of points. Number one, we oppose any bill that allows priority access to a select group of people, in this case the pharmaceutical permit processors, without recognizing the role Virginia farmers and hemp processors should play in this system. The bill as introduced had some role for hemp processors. You all just took that out, so that's a significant problem. We respect the role the pharmaceutical permit processors play. We work with them on a lot of issues. We can't see going that direction in this market and leaving the Virginia farmers behind. There's been talk about 7% of the market. That's 7% of the licenses, not 7% of the market share. Those are two very different things. Whoever goes first will dominate the market share. Quick points. I know you're working with the House to try to get some kind of consensus. You're going in the opposite direction. They're cutting the fee. They're cutting the taxes. They're having hemp processors play more significant a role. The amendments to this bill just rolled all of that in the opposite direction. Passing a bill just got a lot harder with the amendments if this bill goes forward, because this is sending the wrong message to the House. So thank you, sir.
Real quick, so do you agree with also the amendment of a canopy cap, which has also been introduced, that also captures
Yeah,
current
sure.
and future market with a canopy cap per cultivator?
Yeah, and we've talked about this some, and others have talked about some. If you regulate licenses, but you don't regulate canopy, you're not actually regulating markets, and you're going to have real price problems. Who should do that, and whether it should be set by the regulators or by you all, whether you have tiers, all of that is more complex than in the time that we have allotted here. But certainly you all have to take that into account. And again, the process will go to the House, and you'll deal with all of that. That is certainly an issue they're wrestling with as well.
Thank you.
Thank you.
Mr. Chairman, again, Dylan Bishop on behalf of Cannabis VA. While we were wholeheartedly in support of Senate Bill 313 before the amendments, with the exclusion of the hemp processors, I'd like to align my comments with the gentleman that spoke before me. I don't understand this attack on Virginia's hemp processors. We question whether the pharmaceutical processors would have the capacity to
Mr. Dillon, I'm going to interrupt you real quick. Are you telling me that the industrial hemp investments to date have been for the sole purpose of growing cannabis, or the industrial hemp under the code is intended to do?
I'm sure there's folks on both sides of that line. But Mr. Chairman, were the hemp processors able to participate in this as Senate Bill 313 had originally introduced, they would still be set and required to participate at the same standards as the pharmaceutical processors. And again, back to what I was saying, we question whether the four pharmaceutical processors have the capacity to keep up with the adult use market once it opens up. So again, we would just ask that Senate Bill 313 go forward as recommended by the Cannabis Oversight Commission to include both the pharmaceutical processors that play a necessary and important role here, but with also the option to be more equitable to let Virginia-owned hemp processors participate as well. Thank you, sir.
Thank you very much. Next speaker.
Good morning, Mr. Chairman, members of the subcommittee. Susan Gaston on behalf of Purely Appalachia. I've had the opportunity to work and speak with many of you. We've been working quite hard with Senator Eben and his office, but like the speakers before me, particularly Mr. Habib and Mr. Bishop, we regret that we will not be able to support the Senate Bill 313 as amended. We are very concerned about the impact on small business opportunity, on small farms, and we hope that we can go back to the bill in its original form. And I know we have a lot of work to do in front of us, but we're very concerned about how this will impact negatively industrial hemp processors. Thank you, Mr. Chairman.
Thank you very much. Next speaker.
Mr. Chairman and committee, I'm here as a small business owner in Virginia, the Buffalo Hemp Company. My name's Derek Wall, and I am in support of moving up the dates and all this, but I think fairness of market is definitely, if you're wanting to support small businesses and farmers, we farm, we retail. We've been working towards this for 3 years. It's not been an easy battle to try to produce a good business in this industry. So allowing the pharmaceutical companies to have early entry is very negative to my livelihood and other hemp processors that I know in the area of Southwest Virginia. And I would strongly advise you guys to reconsider allowing their early entry.
Thank you very much. Next speaker. Welcome back.
Thank you. Again, I'm here to oppose these bills except for the ones related to space shapes. I'm sorry. The fact is that there's a recurring theme here. That there's a monopolistic theme running through all of these bills. And last year, proper care was paid and attention paid to avoiding monopolistic tendencies. Any of this stuff, you guys need to roll this thing back in order to look out for the little guy. That's my point, and I'm sticking with it. Next.
Thank you so much for joining us this morning. Those in opposition in the Zoom room.
Mr. Chairman, we do have 7 attendees online who'd like to speak in opposition. Aubrey Adams, would you please unmute and begin your testimony?
And as a reminder, we'll do utilize 45 seconds, please, and just provide us what specific points and go from there. Thank you.
Thank you for allowing my voice. I'm from Pueblo, Colorado, ground zero of the marijuana expansion movement. These products made my son irrational and paranoid, and he attempted suicide. He was hospitalized, and they told me it's just marijuana. And I volunteered my family for crisis intervention with the Department of Social Services to find treatment because I couldn't find it. I now live in Houston where I've sought refuge and benefit from a recovery community. My son worked hard and he achieved over 3 years of sobriety, but he started using again, and we haven't seen him since June the 27th of 2020. I am now director of a community called Every Brain Matters, where we try to find freedom from marijuana and call for a cultural change. My story is mild compared to the daily calls I get. Sunday night, I spoke to a family who was told to put their 21-year-old son in a long-term care nursing home because he is permanently psychotic from marijuana. On June the 6th, I spoke at Joshua's memorial service. Joshua was having a hard time. He had his third psychotic break from marijuana, including Delta 8, and jumped in front of a train at the age of 22. A 16-year-old named Breely found her brother deceased after he experienced cannabis-induced psychosis. Her mother, Rita, will be featured on the daytime TV show The Doctors very soon. She wants the world to know the effects of marijuana killed her son. Do you know what it's like to watch a 17-year-old fight for his sanity every minute of the day? I do. I hosted this kid in my home. I have firsthand experiences. Please oppose any bill, especially this bill, and follow the science, not big money, not opinions, because marijuana is now more dangerous and more accessible and more life-threatening than ever before. These high-concentrated marijuana products are not safe for adults to use either. Protect the people of Virginia, not addiction economics. This is a social injustice. Thank you. My name is Aubrey Adams. I'm a former Colorado mom and host mom for Kids in Recovery.
Thank you so much.
Jason Blanchetta, would you please unmute and begin your testimony?
Thank you, Mr. Chairman and committee members. My name is Jason Blanchett. I am owner of Anderson's Greenhouses and Flower for the People in Newport News, Virginia, and Virginia Beach, Virginia. I'm a third-generation small business owner here in Newport News and Virginia Beach, and also a industrial hemp grower and processor. I will sort of second what I've heard before from Mr. Habib and Mr. Wall from Buffalo Hemp Company. It's been a very difficult road in this hemp business, and most of us were hoping to be able to participate as a small business in this new and budding industry. So I just ask that you reconsider some of the language taking out hemp in this bill. Also, Senator Boysko's $6 million entry fee, I think, is utterly ridiculous. And I'll save the rest of my time for everyone else, and I thank you.
Thank you so much.
Mark McCoy, would you please unmute and begin your testimony?
Hey, good morning, Mr. Chairman and committee. I'm with the Cannabis Equity Coalition of Virginia, and I'm representing Lynchburg, Virginia. And I want to let you know today that we strongly oppose moving the date up to July the 1st, 2022. With Virginia being a Commonwealth state, how can we call ourselves a Commonwealth state if we don't have equity in what we're about to do? If we allow these pharmaceutical companies, these medical companies who have been successful since they opened up since the fall of 2020, then that seems that something is unfair there. I mean, what are we trying to do? I mean, are we trying to give them more of an advantage over especially particular small Virginia businesses and business owners? I mean, these medical companies, they already have facilities, their operations, their customers, they're already in place. Don't they have them? They are allowed to multiply outlets in their respective areas of operation. Don't they have all that stuff in place? I don't know about you, but all this seems to me to be a creation of a monopoly for existing medical companies. Where's the fairness in this? It says that the Federal Trade Commission rule is, it tells us that all of this is an illegal setup. Is this really what we're trying to represent here in the state of Virginia, calling ourselves a Commonwealth? What are y'all legislators going to do about it?
I appreciate your time. Thank you for joining us today.
Regina Whitsett, would you please unmute and begin your testimony?
Yes, good morning, Mr. Chairman and members of the committee. I'm Executive Director of SAFE. We're a Substance Abuse Prevention Coalition in Chesterfield County, Virginia, and I'm also a member of Community Coalitions of Virginia. We oppose both Senator Donovan and Senator Evans' bills and moving the date forward. And part of the reason for that is because last year when the bills were written, there was supposed to be a very extensive public health campaign that needed to be implemented prior to the retail sales taking place. And that has not as yet been begun for to educate youth and parents about the harms of the high potency THC products. And I echo what Aubrey Adams was saying. These high potency THC concentrates are what our youth are using. And if these bills do go forward, we definitely recommend capping the THC levels at 10%. And then lastly, in the bills that passed last year as well, there was supposed to be an opt-out option on the November 2022 ballot. And if you expedite the sales of these products to July 1 of 2023, our localities will not be able to opt out of this human experiment. So for those reasons, we oppose this bill.
Thank you very
Thank
much.
you.
Sally Schindel, would you please unmute and begin your testimony?
Mr. Chairman and committee, I am Sally Schindel with Marijuana Victims Alliance, and I want to share with you my son's warning about marijuana. Andy's suicide note read, "My soul is already dead. Marijuana killed my soul plus ruined my brain." Regulation of this product does not make the drug safe. This is the same product, the same risky, harmful drug that the illicit market sells. I'm in broad opposition to all promotion of drug use. My son was an Army veteran, an airborne paratrooper. He was a good man with hopes and dreams and plans. Marijuana ruined his brain and killed his soul. May this never happen to any of you. Loss of a child is a heavy burden, but it will happen. You are working here today to commercialize an addiction for profit industry that will kill some of Virginia's kids. How sad that is. Just think about what you're doing. I hope you'll remember Andy's warning. Marijuana can kill a soul. It can ruin a brain. Please remember to put your duty to protect public health and safety before support of an industry that's promoting use of a very harmful drug. Thank you.
Thank you for joining and sharing.
Michael Krowitz, would you please unmute and begin your testimony?
Thank you, Mr. Chair. I'm Executive Director of Veterans for Medical Cannabis Access. I'm also a member of Virginia's Public Health Advisory Council. I am part of Council nationally, Veterans Action Council. We've spoken to stakeholders around the state. We actually recommended to the Cannabis Commission a community garden program, a designated grower program to help ease some of the transition time and allow people safe access through a community effort, safely accessing cannabis that's grown by their neighbors. We actually were going to get up against this bill already earlier in its earlier form because it creates a serious perception problem out there. We found a lot of confusion out around the state. And just lastly, I think the bill runs contrary to the apparent intent of the program, the agricultural-based program, creating Virginia development. Thank you, sir.
Thank you very much.
Whitney Wallen, would you please unmute and begin your testimony?
Good morning. My name is Whitney Whalen. I work with SAFE, serving Chesterfield County and preventing drug-impaired driving. I come to you today to speak in opposition of Senate Bill 313 and 391, due to the public safety risk they pose on our roadways. According to the Rocky Mountain Hide report, data has shown that traffic deaths involving drivers who tested positive for marijuana has more than doubled since 2013 to 2020. And the percentage of all Colorado traffic deaths involving a driver who tested positive for marijuana has increased by 7%. There's also been data pulled from the British Columbia Trauma Centers, has also shown an increased prevalence of drivers with a THC level greater than 0. I just asked for you all to please consider this data in your deliberation. Thank you.
Thank you very much for joining us today. Senator Eben, as Senator Eben's joining us again, I wanted to appreciate, I think, those who have been in support as well as opposition. There are many different important policy choices before the subcommittee and before the General Assembly at large. And I think there were some good points made by those in opposition in terms of I think Senator Edmund, correct me if I'm wrong, but we did have some of the discussion in terms of whether there's early access, how it interacts with the safety campaign, and I believe one of the ladies just brought that up of how much ramped up time in safety campaign, and I think that sort of helped you inform why, in fact, if there's some early access, that January was preferred to the.
Yeah, it allows more time for public safety campaign. I put in a budget amendment, and I believe the Northam administration did too, for public awareness campaign and health. And just one thing I'll mention, some of the speakers mentioned some tragedies about young people who use marijuana. If we have it tested, we can make sure that it's not laced with fentanyl, it's not laced with ecstasy. And no one is advocating that anyone under 21 be able to access marijuana in Virginia. That would remain not within the law.
Thank you, Senator. The other question that one of the speakers in opposition brought up was the timing of referendum opt-in, out. Can you speak to that?
Sure. So if we were to go with Senator Donovan's July 1st bill, there would be no opting out because the sale would begin. If we go with my bill for January 1st, a November referendum would preclude the retail operation in a particular locality.
Okay. Questions from the subcommittee? Senator Reeves, Senator Kiggins, do you have any questions?
Oh, I'm sorry.
All right, just want to make sure there's opportunity as we wrap up because, you know, I think the key policy questions are the early access to the market as the overall cannabis authority is ramped up. There's considerable social equity considerations. We've addressed some of it in early funding with the fees that Senator Eben has proposed and Senator Boyce has amended to. There's still some provisions that we need to work through in terms of that are written in this, as I understand it, Senator Eben. Maybe you can speak to it in terms of the equity applicants, because that's been an important consideration, and those who have been in both support and opposition have spoken to some part of that.
Sure. In my early sales bill, we require that each of the pharmaceutical purveyors would have a diversity, equity, and inclusion plan that would be required. They'd also be required to incubate qualified social equity applicant retailers for 6 months. So this would, in spite of they would get a head start in the market, but they'd be helping people who might not have run this kind of business or been involved in this kind of business gain the experience needed where they could successfully apply for a license later.
Thank you, Senator Edmund. Senator Sproul?
Yes. Senator Evans, what about the question was asked by a couple of speakers was concerned about those who own a small minority business, that they would have a hard time based on the 6 million and 1 million.
Well, the fee would be charged of the existing pharmaceutical manufacturers who are not necessarily small minority businesses. These are big businesses that can afford a significant fee, whether it's $1 million or $6 million. And that money would go into a fund that would assist smaller applicants later.
Thank you.
Great. And any other follow-up? So the committee also has an action, and that's also to consider the vehicle. Senator Eben has laid out his vehicle, and Senator Donovan has laid out her approach as well. And you know, would be the recommendation of the committee to roll Senator Donovan's bill into Senator Eben and provide the opportunity for co-chief patron. Senator Donovan will obviously have the opportunity on Friday in committee to accept that recommendation or not, should she choose to do so. Is there a motion?
So moved, Mr. Chairman.
There's a motion and a second. Senator Serval seconds.
Okay. I just hate to do it because she's not here.
Yeah, we'll give her the opportunity to not have that action on Friday.
I'll talk to her before Friday and see if that meets with her approval.
Yeah, but as a recommendation of the subcommittee, we'll go ahead and move and second that.
Yep.
That Senate Bill 621 be rolled into Senate Bill 313 with Senator Donovan also being named as co-chief patron. All in favor, say aye.
Aye.
Aye. All opposed? Motion carries. Now, the bill is now before us as amended to move forward, understanding that we still have the larger context of the same questions in terms of access to market, social equity, the larger development of a Virginia brand cannabis with safety provisions under Senate Bill 391.
So moved, Mr. Chairman.
There's a motion to report. Senator Servell seconds. Is all in favor, say aye.
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 Servell say aye.
Servell, Boyce by proxy, aye. Those opposed?
No.
Okay, and McDougall by proxy?
No.
Is a no. All right. Motion carries 4-3.
Okay.
Thank you, Senator Eben.
Do
Senate
you
Bill 391, this is now the bill that provides a more permanent structure of the reenactment provisions from last year's General Assembly session. Senator Eben.
Sure. So I gave the members of the committee a chart rather than go through this entire 198-page bill section by section, but I do want to highlight a few parts. First, I just want to confirm with council, one of the recommendations of the Cannabis Oversight Commission was that all products for human ingestion with THC, including Delta 8, Delta 9, et cetera, would be regulated by the CCA. And that's embedded in this bill as written now, right?
Mr. Chair, Senator Urban, yes, that's correct. Anything that's edible, smokable would switch over to the Cannabis Control Authority.
Okay, I think that's important to note so that we can regulate those and keep them out of the wrong hands.
So just to be clear, anything that is industrial would remain under VDAX, correct, for pure farming side. Anything that results in a consumable falls under the authority, under this bill.
That's correct.
Okay, just want to make sure the subcommittee understands. It's I think, an important policy question. Anything that's for adult consumption falls under the cannabis. If it's pure growing agriculture, still falls under VDAX.
So in the chart I gave to the committee, I noted under notes column whether an item came from the Northam administration as a request, the Cannabis Oversight Commission, or was just a reenactment. Many of them are reenactments, so a lot of them you've seen before. But I'm just going to highlight a few. We had a small penalty for not labeling plants grown at home because without that it would default to a felony, so it's a $25 fine. We maintain the ability to enforce possession with intent to distribute marijuana. It was never our intent to take that away.
Senator Abbott, you're referring to substitute to offer to the subcommittee?
There's amendment. I believe is it a substitute or it's amendments? Oh, I'm sorry. Then I would move the.
So move, Mr. Chairman.
It's a motion. Senator Servell seconds. The motion to adopt the substitute. All in favor, say aye.
Aye.
Aye. Those opposed?
Mr. Chairman.
Substitutes before us.
Maybe now is a good time, but
Senator
I'd referenced this in the wrong bill earlier, and I apologize, Senator Evan, but we wanted to add section 4.1-611. On the original bill, it was line 5328, Mr. May, that would put in the section about waste products after they're cut, seeds and those sort of things, that they just don't disappear, that there's a tracking process for that. Would you like me to read it, Mr. May, or are you good to go with what that would be?
Mr. Chair, Senator Reeves. Yeah, so it would be on the substitute, it would be line 5268. And basically here, we would be inserting a provision of the code that's already become effective, 4.1-611, which is the section that requires the board to create and implement a seed to sale tracking system. And it just adds some language to that section to ensure that from seed to sale and during every single stage and process between there, that it basically applies to every process. So it's just more clarifying language to what we did last year.
And just to make clear to the committee, a technical amendment from the state police that if marijuana was seized from a licensee whose license was pulled by the Cannabis Control Authority, the state police wouldn't be responsible for destroying it. The CCA could have a contractor do that. That came at the request of the state police. We also have VDAX retain traditional food safety inspection duties. We transfer oversight of hemp extracts and smokable hemp products from VDAX to the CCA. On terms of the Cannabis Public Health Advisory Council, we had a marijuana testing lab expert and a consumer advocate to the Cannabis Public Health Advisory Council. We allow the CCA to establish license categories, for example, the size of cultivators to meet demand. What we do is allow them to set all the license caps except for retail. There's still a limit on 400 retailers statewide in the bill, but we give them flexibility in how they meet the others. We allow a governing body of any city, county, or town to adopt an ordinance that prohibits public consumption or consuming or possessing marijuana on public school grounds. Public consumption is already an offense, but this allows the locals to enforce it if they choose. Hours of operation. In the original bill last year, it said that localities could limit the hours of operation. Rather than have localities limit them, I'd like to make it crystal clear that these stores can operate between the hours of 9 p.m. and 8 a.m., which is a bit stricter than the ABC stores, but this is a request of the Cannabis Oversight Commission, and I just tightened it up a little bit.
Senator Evan?
Yes.
Was the original Cannabis Oversight Commission's recommendations to mirror ABC store hours?
It was to mirror ABC store hours, and I just went a little bit further and said nothing between, I believe it was 9 p.m. and 8 a.m. Yeah. Then we did have in this bill the hemp processors had an ability to vertically integrate for a $1 million fee. We update the open container section just to be clear that if cannabis is accessible to the driver or the passenger and in an unsecured or unsealed container, it serves as a permissive inference that they violated that section. We've got, there's some stuff in there about expungement, and what our intent is there's a parallel bill moving through.
Senator Evan, real quick question for council. Based on the amendments to the prior bill, would we need to also amend to make sure the one time, since the previous bill that's reported expires, we need to make sure that the Boys Go amendment on the fee also carries over with the appropriate language to be consistent. Would that be correct?
Mr. Chair, yeah, we definitely need to make them line up at the pleasure of the committee. We could have, I'm not certain whether that fee was intended to be applied as a $6 million fee for transitional sales, separate and apart from a fee that you would later pay for vertical integration, or if that would serve as your vertical integration fee as well.
So I guess to clarify from council, it's my understanding Boys Go's amendment was one-time fee, but theoretically if one was not in market and this transition bill expires and goes away, you'd still need to document sort of that one-time fee as it transitions over of $6 million. That's what I'll make sure we adjust this language to make sure that they tie between the two of them.
Mr. Chairman, if I'm hearing you correctly, I'm thinking that what you mean is that if you pay the $6 million fee for transitional sales, that you wouldn't be required to pay a separate $6 million to vertically integrate. But if you'd never paid a
vertical license fee, then you'd still have to pay.
Yeah, so you would just pay it once, not twice,
not
that
twice.
large amount of money.
Mr. Chair, yeah, so yeah, we would have to tighten that up. I can put an exception to the fee for pharmaceutical processors who have already paid the $6 million fee to engage in transitional sales.
Okay. Is there a motion on that? It's a motion. Servo seconds. Any discussion? All right. All in favor of that amendment, say aye. Aye. Those opposed? All right.
Okay.
Substitutes amended.
And then one change is that it requires the CCA to promulgate regulations by January 1st, 2023, rather than July 1st, 2023, because the goal is that the regulations are in place that take applications for those who would get a license to start on January 1st, 2024. We want to have that in place in time. There's some other recommendations in here. In terms of amendments, one of the amendments that I have is to and I don't know if this was incorporated in the substitute or if it's still an amendment, it's that the resolutions are just whether marijuana establishments are allowed in the locality. It's not just retail store, it's is a retail store or a processor or a grower allowed. So either you're allowed to have marijuana in that locality in the industry or you're not. Is that an amendment or is that embedded in the substitute?
Mr. Chair, Senator Evan, that is in the substitute.
Okay, so it's a change from the original bill. Further, just a clarification that you caught, Mr. Chairman, on the dates of the referendum. The referendum, which would be held in opt-out referendum if a locality wanted to try and opt out, would be on this calendar year. However, if a locality opts not to participate in the marijuana industry, they could have another referendum, but no sooner than 4 Novembers following. Last year's bill said 4 years, and because, an election day might be November 3rd versus November 5th, we just wanted to make it clear it's 4 Novembers following if they wanted to try and opt in later.
Okay, so the substitute has picked up that sort of technical issue on the timing of the referendum, correct?
Yes,
Okay.
and we also we talked about micro licenses last year. This limits such vertically integrated licensees to a total canopy of 8,000 square feet. There's not a $1 million or $6 million fee for those small businesses, but they would have a fee. I don't know what the fee would be, but set by the CCA for smaller businesses. Then there's a limit that the larger processors, the ones with the Head Start, would have the 80,000 square foot canopy size, just as in the other bill.
Okay, so that amendment has already been made to this substitute for at least the concept of canopy caps. Is that correct, Council?
Mr. Chair, yes. So the substitute modifies the canopy in two ways. It puts the 80,000 square foot canopy for the vertically integrated processors and the 8,000 square foot canopy for the small business vertically integrated licensees.
And I did have one other amendment that I apologize I didn't get to council last night. On the original bill, line 6449 to 6453, about importing marijuana into the Commonwealth, making it a significant offense. To delete that because it's a federal offense and it's already an offense to possess more than an excessive amount, whether it's more than 4 ounces or if it's more than a pound, you already have a significant penalty. What I don't want to do is if someone comes over Key Bridge with a gummy in their pocket from DC, they shouldn't have an offense other than if they violate the weight or have it in an open container in the car. We don't want to encourage people to import, but just by the weight limits alone, I think that gets at people who are importing for sale.
Okay. Is there a motion on the?
So moved.
There we go. There's a motion. There's a second.
Second.
This motion is second. All in favor of adopting Senator Evans' amendment, say aye.
Aye.
Aye. Those opposed?
Mr. Chairman, just a quick question.
The amendment
Senator
is
Evans,
adopted. Senator Reeves.
You said you changed the hours from what time to what time?
It wasn't changed. It's just limited. They can't operate between 9 p.m. and 8 a.m. to the public.
Okay, so tell me their hours of operation, because I think.
Well, it's up to the individual stores. They could open at 10 or they could open at noon, but they could not be open
until 9 p.m.
Yeah, you couldn't go in at 10 or 11 or midnight to acquire cannabis.
Mr. Chairman, I think we have a little bit of a conflict in being the law enforcement guy on lines 5413 of the substitute. We're talking about board inspections of records. And if we're really trying to keep a business clean, they should be open when the business hours are allowed to operate legally. And you have 9 to 5 p.m. So I would make a recommendation that we do, if it's 9 to 9.
Oh, well, that's for more of the office records. But if you want to be able to inspect business records at night, that's okay. I don't know if it's necessary.
Mr. Chairman, I will tell you, ABC has authority to go at any time and anywhere to inspect records for
Okay, so
alcohol.
why don't we just say during any hours they're open?
That would be my recommendation to clean that up, Mr. May. If we could just, during the hours of operation, businesses are open.
Senator Reeves, I'm going to ask council to opine because I believe we've mirrored some of the ABC language through this, but if David May, if you could help us walk through this issue.
Mr. Chair, I see ABC has left us because I would have called a friend to come up and talk. I believe we did model the ABC language. I think there are allowances for, as Senator Reeves said, for ABC agents to enter. This is solely for the records piece, so they can go in and make sure they're not doing underage consumption and everything like that whenever. But I do think that we modeled the reasonable hours for the record keeping. Because I think like late at night there may not be employees who could
access those records in the back room.
Yeah.
I got
so
you.
they could go there for sure. This is just about going in to get the record.
I'm comfortable with that, Mr. Chairman and Senator Eben. I just want to make sure that we're not limiting the ability, so to speak, or have to get search warrants or anything like that to do that stuff. Right. Okay, thank you.
Thank you, Senator Reeves. Senator Evans.
Well, those are the main new provisions I wanted to walk through. Are there questions from this chart or about the bill in general, any of the new recommendations? I should say that what we did is we took last year's bill, we sent it to JLARC. JLARC looked it over and reported back to the Cannabis Oversight Commission about where last year's bill differed from the original JLARC report. And then we considered some of their recommendations and adopted them. I would say we adopted, correct me if I'm wrong, Mr. Chairman, I think nearly all of them. There was at least one, and I don't remember which one, that we consciously did not, but we adopted those. Then the Northam administration recommendations were what they considered a cleanup bill that I incorporated into this, just like the thing maintaining the ability to enforce possession with intent to distribute past January 1st, 2024. Let's see. But that's where they came from. From JLARC, the administration, very few for myself. Virginia Normal was the one who suggested they wanted a toxologist on the Consumer Health Safety Board. I changed that to a lab testing expert who would have experience in toxology and a little bit more. We thought that was a more appropriate way to go.
Okay, and you've adopted that in a substitute as well,
Yes.
correct? Okay.
That's correct, Mr. Mayor, right? We put in the lab testing professional.
That's correct.
Thank you.
Mr. Chairman.
Senator Reeves.
I just want to make sure, because we approved all the amendments, to make sure that amendment that I had for that extra code section for the seed and processing, tracking, was that part of that motion? And are we just recommending those to the full committee from the sub?
So we are providing direction to Mr. May on the elements that we need to work into a substitute offered for Friday.
Gotcha.
So if you want to make sure that's clear and clean, I'd offer that motion to make sure that we're document this. And if there's a second.
Second.
All right, it's a motion, a second. All in favor, say aye.
Aye.
Aye. Those opposed? Thank you, Senator Reeves.
Thank you, Mr. Chairman.
Mr. May.
Mr. Chair, just to clarify, to wrap up on the fee before we move on. So my understanding is if you paid the $6 million to engage in transitional sales, you will not later have to pay a fee for vertical integration. But if you did not engage in transitional sales and you would like to vertically integrate, what would your fee be?
That's the same.
It would be track the same fee as the other bill, so $6 million if you hadn't already paid it.
That's right.
Okay.
And for folks who are watching, that's for the largest people who are getting a market advantage.
Mr. Chairman?
Senator Sproul.
So based on that, so how are you going to, the last statement, so how is that hurting the minority business who want to get in, who going to pay that $6 million? I can understand the first part, but the second part just got through saying that would hurt the business, those who, the small minority business, would that kind of hurt them for doing that?
No.
So, Senator Eben, if I might, because this is a good part of our discussion on the Cannabis Oversight
Yes, sir.
Commission, one of the issues for our social equity candidates and those who are in small business is actually access to capital. And one of the things that the early larger fee seeks to increase is the early access within the equity fund to actually have the capital necessary to fund the small businesses and those impacted within Virginia to have cash capital. Otherwise, as currently stated, and with the potential proposed lower tax rate, there's less funds available over time to reinvest. And so one of the things I think Senator Boysko is seeking to do is to make sure that there's enough capital up front to help those equity applicants in the process. Otherwise, there would be, because of the federal banking restrictions, access to capital and cash becomes very difficult in this market to do startups. And so I think that's what Senator Boyska is trying to also address at the same time as making sure it's well capitalized. We discussed it at the Cannabis Oversight Commission as well.
I was speaking of the last portion that Mr. Mays just got to. I was speaking of that. That's different. Is that right, Mr. Mays?
Mr. Chair, Senator Sproul, the fee would not affect the small businesses who wish to vertically integrate, so it would only apply to the processors. And as Mr. Chair was saying, it would, be used to help those micro
businesses. Thank you. Thank you so much. Thank you.
Chair. By defining the canopy
answered
cap,
much more succinctly than I did.
And Mr. Chair and Mr. Senator Sproul, by defining the canopy cap at 8,000 for these small micro businesses that we would allow to vertically integrate, we're giving small businesses a chance who might not have the capital to do a big, huge operation to possibly even get a loan and to have a way to move forward.
Mr. Chair.
Senator Boyska.
Thank you. So I know I've missed some stuff, but I just want to say that this, for me, is the linchpin. And I'm very grateful that we are considering it in this way. We have to have a social equity piece.
Thank you, Senator Boyska.
Mr. Chairman.
Senator Reeves.
I can't keep racking this pellet in my brain why we went from 1 to 6, but I'd just be curious because I really don't know, and you know this, Mr. Chairman, we've talked. What do other states do to be able to get a license to buy in? Because I don't know anybody other than people that are putting businesses together with a lot of money that are going to be able to tap into $6 million. And I know we're printing money by selling weed, but I just would love to know what other states are doing because that just seems exorbitantly high. And I mean, we started at 30% taxes on weed, and now we're down to 21. Yeah. And where's that soft spot? Because you're talking to a guy who used to work undercover narcotics. I know what weed sells for, and I just want to make sure we're not driving everything to the black market.
I can review by Friday the JLARC report or talk to JLARC about what other states did. I will say that the fee, whatever the fee is being imposed on people who are getting. They've already invested a lot in their operations, the pharmaceutical people, and we want them to remain in Virginia because they have invested a lot. And in spite of what's been said, I don't know that the pharmaceutical alone has brought them these enormous profits, but they will have enormous profits when they are one of the people who are given a 1-year advantage to sell to the general public. And they're large companies. Whether the right number.
Mr. I have to talk to Senator Evan. We're sweet mates, but we can talk afterwards. But that's just something that's racking in my brain. I think some others in the audience are worried about it as well.
We will talk to JLARC about other states before Friday and get with you, Senator Reeves, hopefully tomorrow.
Thank you. And Senator Reeves, I think you bring up a good point, which is the overall long-term illicit market capture. What are the transitions? What are the opportunities for small business in the market? And I think those are all things that we're going to be tackling in both full committee as well as when this bill goes over to the House, and likewise the House back to the Senate, to make sure we figure out the right fit and balance that meets everybody's needs as closely as we can. I don't think we're going to have a perfect solution to any one of the challenges that have been proposed to us today. Senator Eben, anything before we get into public testimony? Because I want to make sure we have.
I think you have the essence of the bill, and this chart should help provoke you if there are other questions.
All right. Thank you very much. So those in support of Senate Bill 391, please move forward. And also, if you're in the Zoom room, start to raise your hand so we can organize that as well. We're going to do the same thing, limit to about 45 seconds, and try to take in as much information and testimony as we can.
Mr. Chairman, members of the committee, Greg Habib from Gentry Lock here on behalf of Broad Coalition of Virginia Farmers and Hemp Processors. We're generally in support of a bill moving an omnibus bill and trying to get to a conclusion. I do want to point out a couple of issues that hemp processors will have with this bill as we try to get towards passage. Number one, everybody talks about the amount of profits in this industry. It's not nearly what y'all think it is. There's a lot of revenue. The way the federal government taxes revenue in this business, profits are just not what people think. The idea that 21% plus 4 taxes is sustainable is unrealistic. The taxes are too high. The fee is way too high. For hemp processors, it's unclear if they vertically integrate what retail license access they could have, and they can't invest until they know that. The idea of waiting on referendums for growing, cultivating, and processing until November is a problem because nobody can invest in the infrastructure needed until next year. So by wrapping all those licenses into the referendum, you've created a new problem that's a barrier to the Virginia businesses. And then at a high level, again, I'll say this bill is moving in the wrong direction relative to where the House is going. It's not your job to compromise now, but it just got a lot harder to get a final bill with what happened this morning.
Appreciate the opine of which house has a right or wrong direction. Thank you so much for joining us this morning.
They're both going the wrong direction.
There we go. There we go. Equal opportunity, bicameral response. Thank you so much. Mr. Johnson.
Yes, sir. Scott Johnson for Golden Piedmont Labs. And again, trying to catch up with the substitute and defer to my good friend, Mr. May. But I want to make sure in the substitute language on industrial hemp extract, if it is going to be edible, if it's going to be vape, or if it's going to be wiped on you, we understand that's going to be regulated through the Cannabis Authority. But don't let the delineation line be whether it is a synthesized process or not, because all of it is. That's what happens in the processing. That's the only clarification. It may already be in there, but just wanted to put that clarification out.
Thank you very much. Next speaker.
Mr. Chairman, members of the subcommittee, Hunter Jamerson for Jushi again. I appreciate all the work that Senator Evan has put into this issue. His leadership has been admirable and something I've found incredibly complex, and we certainly support the reenactment of licensing provisions for the adult sales program. I wanted to comment briefly on two items. I look forward to discussing with the subcommittee and Senator Eben whether $6 million is the right number, but a full commitment to investment into standing up social equity applicants, social equity investments into incubation as well. Likewise, wanted to raise on the issue of the referendum, I'd ask you to be mindful the processors are bound to our health service areas. We've already constructed our processing facilities, already constructed our cannabis dispensing facilities. We must operate and co-locate in those spaces. So ask, as you work towards a referendum, consider appropriate exemptions for that licensing reality. Thank you.
Thank you so much.
Mr. Chair, members of the committee, J.M. Padini on behalf of the National Organization for the Reform of Marijuana Laws. Thank you, Senator Eben, for carrying the reenactment legislation. We appreciate your work on this issue. We would recommend that the word cannabis be used in place of marijuana throughout the Cannabis Control Act. Thank you.
Thank you.
Mr. Chairman, members of the committee, I'd just like to reiterate to all of you guys that this is, very important to thousands of business owners in Virginia, farmers, and if you allow this early entry for the pharmaceuticals companies, they're going to get so much market share. They're already doing it now. So the thought that they're going to be able to come in and have retail sales on top of their medical sales is just, to us, is just unfathomable. So I just would rather, work a way for small businesses to go in at the same time and have a fair marketplace versus this unfair advantage. Thank you.
Thank you very much. And I want to make sure that the gentleman, thank you for joining, that Senator Eben also included a provision of a canopy cap. And so one licensee is equivalent only to the yield of the canopy cap. That ensures future market cultivation opportunities by providing that cap. If we didn't, I think we'd absolutely agree, but I want to make sure to note that the substitute that Senator Eben has offered includes that sort of cap and provision. So thank you. Just want to make sure you address that. Thank you.
Say one more thing?
Sure.
So I think you're talking about the 80,000 square feet.
Of canopy.
That's a lot of canopy. And if you're allowing them that much growth, I just think that'll kind of knock out the small guys pretty quickly. So I agree that there needs to be some kind of cap on it. I think the fair playing field needs to be everybody rolled out at the same time. So thank you.
Next speaker.
Mr. Chairman, members of the committee, Matt Benke with the Virginia Leaf Company. We support the bill. The one thing that we'll ask you to continue to look at is the time frame that the smaller guys can get up and running. I think right now there's a concept that there might be a delta of about a year. I'm worried that it might be significantly more than that, so that'll be the issue that we continue to express some concern on, but we support the bill. Thank you.
Thank you very much. Those in the Zoom room in support?
Mr. Chairman, we do have 5 speakers. Jennifer Gilmore, would you please unmute and begin your testimony?
Mr. Chairman, members of the committee, my name is Jennifer Gilmore from the Office of the Executive Secretary. We actually have no position on the bill, but we have some concerns that are limited to the sealing and expungement portions and the resentencing provisions. If the committee wants to hear those concerns today, I'm happy to address them today, or I can reserve my comments for another time if that's not on the committee's agenda today.
Mr. Chairman.
Senator Servo.
Thanks. I have a sealing and expungement bill, which I think deals with some of these things, and that's going to be heard in the CRIM subcommittee either this afternoon or Friday, and I suspect we'll conform those provisions to whatever is in Senator Eben's bill at the end of the day. And I've been working with the Supreme Court on this, so I suspect.
Yeah, we will conform this bill in finance to whatever judiciary comes up with.
Okay.
Yeah, so yeah, if you can take those up in judiciary, we'll be tracking these and incorporating these. This bill will be going over to the Senate to from rehab to finance, and so there'll be some opportunities to make sure we pick up any of those amendments in between the journey between one committee and the other.
Yes, thank you.
Thank you. Next speaker.
Sally Schindel, would you please unmute and begin your testimony?
I will be speaking in opposition to this bill. You may delay me if you would like.
Thank you.
Aubrey Adams, would you please unmute and begin your testimony?
I am also in opposition to the bill, so I can be delayed too.
Ryan Suit, would you please unmute and begin your testimony?
Mr. Chairman and members of the committee, my name is Ryan Suit, and I'm a resident of Virginia Beach, Virginia. I'm the co-owner of a small hemp and CBD business, and I'm a registered hemp grower and processor, and I also work with a group called Dominion Cannabis. I very strongly support the new cannabis industry in Virginia, and I'd like to echo the thoughts of Mr. Habib from his testimony earlier, as well as ask that you support all the bills that move the cannabis industry forward so that the commercial market may be established as soon as possible. Thank you.
Philip Thompson, would you please unmute and begin your testimony?
Yeah, Philip Thompson again with Cannabis Equity Consultants. I support aspects of the bill, and I'm against other aspects of the bill. The expungement stuff is really important, and we support getting that squared away so people can get that stuff off their records and move forward with their lives. I'm going to come back to social equity. I work with Senator Eben and with the industry and trying to provide information and language, all of which was ignored under the current social equity provisions. You either have to be a criminal, have a criminal in your family, live in a bad area, or go to an HBCU in Virginia. Done none of those. A lot of Black small business owners and other minorities haven't done any of those. So we're not going to be. We're out of being the social equity. Get into the social equity part of this. So I think that needs to be pulled out and readdressed, and get a real social equity program, and also look at the timelines and try to get this done as soon as you can, so that small business and social equity growers can get into this market before it's going to be completely dominated. Because we agree with the comments earlier that if you let the medical cannabis people get in like that, they're going to dominate the market. It's going to be hard for people to get into this market. So we hope that that you will look at these social equity provisions again.
Thank you, Mr. Thompson.
Mr. Chairman, those are all the Zoom testimonies in support.
Okay, those in opposition, we'll start with those online first and then jump to those in the room.
Sally Schindel, would you please unmute and begin your testimony?
Thank you. Again, I'm Sally Schindel with Marijuana Victims Alliance, and I'm here because my son died from his marijuana use. Marijuana-induced suicide. His note read, "Marijuana killed my soul plus ruined my brain." I'm in opposition to anything, anywhere, that promotes the use of marijuana. It's a very, very harmful, dangerous drug to far too many, including all of you in Virginia, as well as anywhere else in the country. I'm in Arizona, but I see it all over the country, and it's growing worse and worse as the potencies grow and grow. To listen to your work today is just painful to me, because you're in there, you're trying to compete with an illicit drug market. They're not going away, and you can't win. And look at the work you try to do, and you try to be good people doing that. And the illicit drug market, they don't have to go through these processes. It just makes me so sad to see how hard you work to do something that's so impossible. It's a very, very harmful, dangerous drug. Anything that can be done to stand in the way of promoting the drug any further is what I would like to see being done.
Thank you so much for joining us again.
You bet.
Aubrey Adams, would you please unmute and begin your testimony?
Hi, my name is Aubrey Adams. I'm a former Colorado mom who sought refuge in Texas. I'm director of Every Brain Matters. It is absolutely horrible and inexcusable to be advancing and spending the marijuana use. Spending this much time to enable addiction and mental illness is a social injustice. Dr. Nora Volkoff of NIDA, the National Institute of Drug Addiction, just said on a live webinar that marijuana is causing psychosis in all ages, not just use, and that there is a very high correlation to the suicide rate increasing because of this marijuana products. This is not a solution. This is a nightmare. Please do not spend more time enabling and abetting an organization that profits off addiction and mental illness. Like I said, I just spoke at a memorial service of Joshua. Joshua was 22 years old. He jumped in front of a train. He worked hard to get sober. He worked hard. He achieved it for about 6 months and he stabilized. Marijuana is a life-threatening drug. Do not enable or expand any more marijuana use. Promotion is not a solution. It is an epic nightmare. This has failed in every state. Dear legislators, do everything you can to stand in the way of this expanding this industry.
Thank you very much.
Anthony Jones, would you please unmute and begin your testimony?
Thank you all once again. I did introduce myself earlier, small black farmer here in Dinwiddie County, also wanting to make comment about the social equity criteria as it currently stands. I'm going to use a strong term here. It's literally, in many instances, it's almost borderline discriminatory, and I can prove it. The amount of time that I have to explain that is limited, but I'll give you a teaser to tell you what I mean. I started my education at Virginia State University, but opportunity made it so that I attended VCU and ultimately Liberty University to get my master's degree. White students can attend an HBCU, and they would be qualified for social equity provision. But because I do not or did not graduate from an HBCU, I'm eliminated. So in that particular standpoint, it becomes exclusive. And there are more aspects to this criteria that are suspect that I'd like to have an opportunity to send written documentation to prove this point and to also expand on it further at a future opportunity.
Thank you so much, Mr. Jones. And please do provide any written information that's helpful to the committee to consider. And also, please also take a look at the JLARC report from last year, also trying to tackle the pool of social equity applicants and the implications of what was in the current legislation to what's proposed. So lots of information out there and lots to consider. Thank you. Next speaker.
Regina Whitsett, would you please unmute and begin your testimony?
Good afternoon, Chairman and members of the committee. This is Regina Whitsett from SAFE and SECOVA again. And I just would like to encourage all of you to view the General Laws Committee recording from last night. Dr. Bertha Madras from Harvard spoke, and Dr. Marilyn Eustace spoke, and Dr. Michelle Peace from VCU spoke. And I think every legislator needs to hear that recording before these bills move forward. Also, I wanted to mention and ask a question. I'm sorry I haven't read the whole bill, but last year there was a right to work language in this bill, and it was in Governor Northam's amendment, and I just want to make sure that that's not in there this year because that was a reason that it was opposed by a lot of people last year. And going back to a couple other issues, data needs to be collected before we move forward with any type of recreational marijuana sales in Virginia. We need to know traffic fatalities. We need to know ER visits. We need to know suicides from marijuana usage. Data needs to be collected so we'll have a baseline. Also, in addressing the referendum issue, again, I'm hesitant to do this, but because we are in Chesterfield County already moving forward with an opt-out referendum, but the language in there is very specific and confusing to the public. And we know that Delegate Ware has House Bill 43 out there, which is an opt-in bill. And I don't understand why legislators are putting the burden on communities and counties to opt out of this experiment versus allowing the people that want to participate in it to opt in. So I would ask that you look at that language about opting in rather than forcing counties to opt out and educate their constituents.
Thank you.
And lastly, I want to say in Chesterfield County, I've had to call the police on a marijuana flag next to an RX drugstore next to Thomas Dale High School. So I really encourage you, if any of this moves forward, that you really narrow the advertising scope of the cannabis industry and you make them keep the advertisement out of the eyesight of our youth in our community. Thank you.
Thank you for that. And I believe we'll have Senator Eben address the advertising in a moment after we go through this. So I just want to make sure he does the notes because I do believe he's addressed a part of what you just indicated. Next speaker.
Jason Blanchett, would you please unmute and begin your testimony?
Yes, sir. Thank you again, Mr. Chair. Committee members, again, Jason Blanchett, third generation greenhouse grower, farmer, Newport News, Virginia Beach, Virginia. Been in hemp almost since day one when the feds regulated industrial hemp growth. I just wanted to say I'm probably one of the only people that has spoken that has actually grown hemp in quite large greenhouses as well as my other plant crops. There is a huge delta between 8,000 square feet and 80,000 square feet. So I just ask that the $6 million fee that's been floated around, the $1 million fee for somebody like myself that is still a small family business that is growing hemp in 25,000 square feet of canopy, I don't feel should be pushed by this $6 million entry fee. And again, our small businesses, the hemp processors, the hemp growers of Virginia should definitely have a seat at the table day one when this comes to pass, in lieu of all the pharmaceutical processors getting a jump start on us. And that's about all I have. Thank you so much.
Thank you, Mr. Blanchett. And just to clarify, the $6 million fee is applied to vertical integration only, not to cultivator licenses. So I just want to make sure that's clear. But thank you for the testimony and also providing your experience. Those in opposition here in the room.
Yes, Mr. Chairman, thanks. Tom and Torcio with the Virginia Catholic Conference. I think it's everyone here on the subcommittee knows about the burgeoning mental health crisis that continues to rage in our Commonwealth. In the midst of the worst pandemic that we've probably seen in our lifetime. And so we know that commercialization of THC, high-potency THC in particular, is going to only exacerbate the mental health fallout that is currently plaguing our hospitals and our healthcare system and our providers and our frontline medical professionals. Suicide rates are also at disproportionately high rates among Black and Brown communities, as are overdose rates. So we have probably the worst mental health crisis we'll see in our lifetime, and introducing a new addictive substance with the branding and marketing of a addiction for profit industry that is multinational and global in scope is only going to compound the burden on our healthcare system and our healthcare providers who are already suffering from their own mental health crisis. So with that being said, we would ask you to please oppose commercialization for the benefit of Virginia's children and our healthcare community. Thank you.
Next speaker. Good morning.
Good morning, Mr. Chairman. Thank you for having me. I'm going to try not to cry. My name is Linda Moore, and I'm from the Richmond area, and I speak in opposition. My 21-year-old son, not believing that pure HC could cause his prior episodes of psychosis, smoked again. Again, he immediately became psychotic. He ran into the traffic and got hit by a car on Chippenham Parkway, going 45 to 50 miles an hour. Amazingly, he completely recovered after being on a ventilator in the ICU for a week. Only THC was found in his system. At this point, we desperately, but not successfully, tried to find my son help. All calls became dead ends. None of the rehabs in and around Virginia treated pot addiction as a primary diagnosis. Through my research, I did find myself some amazing support from my now friends in Colorado and other states that legalized marijuana years ago. Here is also where I found many stories, just like my son. Tragically, some ending in suicide. In these states, they have support groups for Marijuana Anonymous and Maranon for people who need support for their loved ones affected by marijuana. Finally, we found my son a rehab that was over 1,000 miles away and was $35,000 our cost. He finished the program, he came home free of psychosis, continued his addiction recovery, and was weaned off all medication. And today he is doing well. So you might ask, why would just pot cause all this havoc? Because marijuana in the 60s, 70s, and 80s had an average of 2 to 6% THC. Today in Colorado, the average marijuana flower has 19% THC. Some concentrates have up to 90% THC. Adolescents and adults well into their 20s whose brains are still developing cannot handle today's marijuana. I ask you to think about the lack of support available here in Virginia and think about the differences between yesterday's marijuana, which is what I think you're legalizing, and the dangers of today's marijuana. Thank you.
Thank you so much for sharing your story.
Thank you.
Next speaker.
Mr. Chairman, ladies and gentlemen, I'm Marty Jewell again with Cannabis Equity Coalition of Virginia and the Richmond Crusade for Voters. I think I've driven home my point that we plead with you to take special care in not draining the equities that was in the bill originally. And I've got material here that I'd like to leave with you, if I may. Who do I give it to? This nice lady.
Thank you.
Thanks a lot.
Thank you so much for joining us today. Senator Eben.
Yes, there was a question about advertising. I want to make it clear that the bill provides for no outdoor billboards in Virginia. It disallows advertising, I believe, within 1,000 feet of a school and similar institutions. Further, it says that advertisements are to be in mediums that are geared 85% or more to 21 and older, meaning that you wouldn't see it running during TV shows and the family hour. They base this on radio and TV ratings when they tell who's watching something, so you wouldn't see that. I would expect most advertising would be on the internet for people who are searching for it, and the most important safeguard in the stores is that no one under 21 would be admitted, and you would lose your license if you did so.
Senator Eben, your original bill had and allowed for outdoor advertising. Does your substitute address that issue?
There's a spot in the substitute where it says there's no billboards. Maybe council could clarify.
Mr. Chair, Senator Eben, the original bill and the substitute allow for outdoor advertising. There are restrictions on outdoor advertising. Billboards are not allowed, but other forms are, depending on where it is.
Yeah, they can't be within 1,000 feet of a school or similar institutions. I'm not really aware of what outdoor advertising exists outside of billboards. I'm sure there must be things, but if the committee wants to trim that further, we can.
Mr. Chair.
Senator Boysko.
So tobacco use, we don't allow tobacco ads on TV or on the radio, correct? I would move that we make the policy for our cannabis in line with that.
I would ask council, are we allowed to regulate like airwaves or within the state? Is that doable? For a Virginia business, we can do that?
Mr. Chair, Senator Eben, we started to go down this road some last year, and we've got some feedback from the Attorney General's office regarding their concerns related to the First Amendment. So I would just say that there are some restrictions we could place within inside of the state. It's a very gray subject matter, so we just need to be very careful if we're going to start tweaking that we do it in a way that's permitted under the First Amendment.
I don't know if it's appropriate to ask counsel or if I should ask JLARC about restrictions in other states in case the committee wants to tweak it further. Is that something that you can explore what other states do, or should I ask JLARC that? Okay, I'll talk to JLARC about if there are restrictions
Thank you, Senator Edmund.
on TV and radio advertising and try and address it as the process.
Senator Kagan.
I just wanted to make a second to Senator Boysko's move. If that's an amendment that you'd like to propose, I second that.
So at this point, it sounds like an amendment in concept with, recommendations of reporting back on the issue.
I don't need to even wait for that. I second what Senator Boysko said. I don't think there's a place for it in any type of advertising, not television, not radio, not billboards. I think with this age, kids are taping things all day long. So I know that as a mother, at least when my kids watch things that are taped, they're seeing everything. So
yeah, it'd be friendly
so
amendment
I
to me
agree
if
as far as the tobacco piece goes. We don't.
Mr. Chairman.
advertise
Senator Serval.
Thank you. So, I would just ask council, do we have any advertising restrictions on alcohol in Virginia, under Virginia law?
Mr. Chair, Senator Serval, we do, and a lot of this aligns with those restrictions, but they are not identical.
Yeah,
I am
council elucidate the differences?
I am not prepared to.
His encyclopedic knowledge is not prepped for the crosswalk, it sounds like.
I'm happy to look into that and work with the folks of ABC to identify all the differences of the question committee.
Senator Serval.
That's one hell of an amendment in concept, and I'm not sure how council could even craft it. And I'm not sure tobacco is the proper analog here as opposed to alcohol. And so, I'm not sure if I'm comfortable voting it because we're really treading on some really dubious constitutional ground. There's also, I don't think there's federal preemption issues when it comes to cannabis because the feds are out of it, but there obviously are on tobacco. But that's a really complicated, advertising is a really complicated thing to get into. And I'd also just be curious what other states have done. There's a lot of questions to ask. That's a big pull. So, but I think it's worth exploring. I just think it's a big pull to do like we're doing it right now.
Any other discussion? There's a motion and a second on some of the suggestion expressing some concern.
I will consult with the state attorney general. I'm fine with the amendment being that no licensee could have a TV or radio ad, but but that doesn't preclude the internet. But I'm going to call the attorney general's office, and I don't know that they can give me an opinion by your committee meeting on Friday. But if they have issue or want to help me construct it as this moves through the process, I'm happy to tailor whatever we can get away with.
Mr. Chairman,
Senator McDougall.
I think what I'm hearing expressed from Senator Kiggins and Senator Boysko is that they would expect that whatever final product we come out with would have advertising restrictions that were at least as restrictive as tobacco and alcohol in Virginia. So whatever we do, we would not want marijuana to be advertised more than those two items.
That's correct.
So if Mr. May can figure out that analysis,
Mr. Chairman,
because he has nothing else to do.
Senator Serval.
I get that the problem is that alcohol and tobacco are not first of all, I don't think there's rules on tobacco. It's state rules on tobacco from what Mr. May said. So we're really talking about alcohol, I think. But I'm also just not sure, Mr. Chairman. I remember when I was in 12th grade government class, we were talking about interstate commerce clause in the Constitution. One of the questions I asked my government teacher was, who gets to regulate the TV signal that goes across state lines? Because that's kind of a federal thing. I thought it's all federally licensed, and so these are the kinds of things you tread into when we start playing in this space. And so I don't know what the rules are. So I understand what Senator McDougall just said, but I'm pretty sure that alcohol and tobacco rules are different, and so I don't know how you reconcile the two.
Senator Eben.
I will bring some more information to the committee by Friday, but if Mr. May can accomplish an amendment in that spirit, I'd be fine with it.
All right. We find with taking this up in committee as a separate action and not adopting as of yet, so we get some more information. Senator Boyce, go.
Yes.
All right.
Yes, thanks,
So
Mr.
you
Chairman.
withdraw the motion at this point.
And we could have counsel prepared.
You know, at the federal level, it's still not legal, so I don't think that it's protected as alcohol or tobacco would at the federal level. I think that I would like to see us push forward to try to get this amendment through and let somebody else tell us that it's not okay. I mean,
All right, so
I'd like to continue the amendment today, vote on it, and then later, if we have to change that.
there is a
so
motion
be
and a
it.
second in concept to align the advertising requirements between generally tobacco or ABC advertising rules. All in favor, say aye.
Aye.
Aye. All opposed? Motion carries. Good luck, Mr. May.
If anyone's watching and they want to get with my office about advertising restrictions, please contact us.
Yeah, Adam's office is open for all the advertising folks who want to now come visit his office. Senator Eben, you want to wrap us up with the overall concepts and where we're at?
Yeah, I think that what we're moving towards is a well-regulated adult use market with a product that's limited to those 21 and over, and with, whether through early sales or otherwise, a tested product that is not laced with fentanyl or ecstasy, and that we can try and keep away from youngsters who want to clamp down on the illicit market and not have organized crime be the purveyor of this product. And adults can use this responsibly. I'm not suggesting that marijuana is for everyone to use, and people who have any kind of existing mental health issue should either not use it or consult with a medical professional as to whether or not it would cause a complication. But people have been using this for thousands of years. Virginians are using it. We recognized that when we legalized last year, and it is possible to use it responsibly. I think we've got a well-constructed bill. We've looked at it. JLARC looked at the original bill and informed the original bill along with Governor Northam's work team. And now that JLARC has looked at what we did last year, made recommendations, Cannabis Oversight Commission has studied it, and I think we've made some improvements. And I'm sure there'll be more improvements as this progresses.
Thank you, Senator Eben. I know you've put a lot of work into the feedback through the Cannabis Oversight Commission, like you said, in JLARC and many others, to put together sort of the reenactment portion of this bill, as well as make the tweaks and adjustments necessary to move this forward, with the understanding that right now possession is legal in Virginia, and so finding a pathway forward to make it more consumer protected and safety labeled. I think there's some provisions that have included in that, as well as the ramp up time to ensure that the public safety campaign also is in place, which is significant. Follow
Mr. Chair,
questions as
I
we wrap up.
apologize. I had to leave to go present a couple of bills, but one of the things that I have concerns about is the vertical integration and allowing people who are already in the business to be able to jump in and have a head start. We heard some folks who had testified it. I'd like to make a motion that we remove industrial hemp processors' ability to vertically integrate.
All right, there's a motion. Is there a second? There's a motion and a second. Discussion on the motion. All right.
Mr. Chair, I would just say, they're going to have the opportunity, just like everybody else, to make that application at a later point. What I've heard from the testimony today, and has always been my concern, is that we don't want to give anybody a head start who is already, I want to make sure that there is a fair play for the people who have really been struggling, and I believe that this would help. But they would still have that ability to apply for a separate license, just like anybody else would at the appropriate time.
Thank you, Senator Boyce. I know that's been a concern from last year's discussion around the bill in terms of vertical integration and whether or not allowing more of those folks to participate in vertically integrated actually blocks out the smaller markets due to just the size and leverage of the market force involved. So Any other discussion on the motion? All right. The motion's before us. All in favor say aye. Aye. All opposed?
No.
All right. Motion carries 4-3.
Bryce Reeves is a no as well.
Bryce is no. Yep. Thank you, Senator Boysko. Any follow-up items as we move to wrap up? All right. The bill as a substitute, as amended, is now before the subcommittee. Is there a motion?
Move to report to the full committee with amendments.
So motion to report, second.
Right. Where's this going next?
This is
Finance?
going to full committee on Friday.
But then finance, right?
Correct.
So I think it's a motion to recommend reporting and referring to finance.
That would be fine. Senator Boysko is amending her motion.
Thank you. I'm second.
And I'll second that.
There we go.
Whatever.
There's a motion, a second, to report and re-refer to finance. All in favor, say aye. Aye. Sproul, aye. All opposed?
No. Senator Reeves is
Senator
no.
Reeves, no. Motion carries 4-3.
Thank you, members of the committee, for your work, and we'll continue to work on this. Thank you.
Thank you. Yeah, and for those participating, there's still a lot of time and work to be done through this bill. It's going to go through both full committee on Friday, likely be re-referred to finance. We also have crossover, likely of a House vehicle that's going to come over to the Senate to work through as many of the different provisions that we talked to today. I think that all folks, whether for or against, are very interested in having, based on having cannabis legal, having a safe product and having some consumer information in relation to it. And as we move the markets forward, we do want to make sure that there's opportunity built, social equity opportunity, as well as funding availability to connect those dots. So we still have a lot of work to do, and I appreciate everyone's time and participation today. It was very informative for those who are both for and against. So please look forward to your emails and comments as this moves forward. And the committee will rise.